Good job. Good job. We are live. We'll call a meeting to order. First order of business is roll call. Can the LSO run us a roll call?
Senator Beitman.
Here.
Senator Coe.
Here.
Senator Rothfuss.
Here.
Senator Wasserberger.
Excused.
Representative Burkhart. Representative Crank.
Here.
Representative Duncan.
Here.
Representative Ayer.
Here.
Representative Furphy.
Here.
Representative Henderson.
Here.
Representative O'Hearn. Representative McGuire.
Present.
Co-Chairman Greer.
Here.
Co-Chairman Anderson.
Here. The decorum, we want to remember to keep it civil and not interrupt anybody or not argue with anybody on the Zoom. For you House members, you don't have to wear your masks for this meeting. We have a new member today, and maybe we'll give him just a minute to introduce himself. Representative O'Hearn, do you want to introduce yourself just a little bit? Turn your mic on. Turn your mic on. There you
Sorry,
go.
you got me now?
You got it.
Okay, thank you, Mr. Chairman, committee members. I'm honored to be appointed to replace Monkey Laux in his term. Here's a little about me and my background. I'm married, have been for 35 years to my lovely wife, Carol, planning on another 35. We have 6 kids, ranges from 19 to 32. The 19-year-old still living at the house. He's going to Casper College, works part-time to pay for it. Our 4 kids here in the Casper and Mills area. I have 1 in Colorado with our 3 grandkids, and 1 is stationed in Japan in the Air Force. I'm a general contractor, and I'm presently the building official and assistant town planner in the town of Mills. I've been building and remodeling homes for 45 years. During that time, I was in the Wyoming Army National Guard for 31 years. Deployed twice to Iraq. As a general contractor, I was hired by the city of Casper to inspect and write all the RFPs or requests for proposals for all the nonprofit businesses and low-income residential housing for Casper's Community Development Block Grant funds. The town of Mills hired me to help with the building department as the building official and town planner. I still enjoy building projects when I'm not spending time with family and friends. I am newly interested in politics and how it really works, so this is all going to be new to me, hence the background, as I feel like an alien so far. But I'm a quick study and I listen to people before making a decision and always try to help out in any way that I can. I ran for this seat because I don't like the way the country is heading. Because of, and for my 6 kids and 3 grandkids and all the people I know and love, I'm going to try and do what I can from this higher platform to return America and these United States to the country I fought for as a military officer and now as a very concerned citizen. I look forward to getting to know and working hard for and with you all to do the right thing for every citizen of this great state and ultimately this one nation. Thank you, Mr. Chairman, for allowing me these few minutes to introduce myself to you all. And I'm glad to be here.
Oh, good. We're glad to have you. Glad to have you. I should go over the rules a little bit. If you want to speak, raise your hand, just put your hand up and so that I can recognize you. I got you all on the other screen now so I can see you all. So I can see when you're needing to speak. So the first issue, order of business for us is the tax lien issues. And I think the LSO is prepared to introduce some bill drafts.
Yeah, Mr. Chairman, members of the committee, you should have 21 LSO 71 draft .4 before you. This draft is virtually identical to the draft the committee looked at the first meeting the first regular meeting in June. Just to refresh everyone, I'll briefly go through it. What this draft does is amends provisions for perfecting tax liens on mineral production, as well as the requirements for notice of foreclosures for tax lien sales. So just to jump in, the first change is on page 3, line 14. This is language that applies to liens on mineral production before January 1st, 2021. And it strikes language that was inserted in last year's legislation regarding new owners not being subject to a prior lien if the new owner or the new person who's producing the minerals shows a certification that the taxes imposed were current or have been settled or released, or payment terms had been agreed to. On page 4, line 10, this is language that applies to liens on mineral production on or after January 1st, 2021. And this strikes a reference to an exception and superiority of a county lien that exists before January 1st, 2021. Page 4, line 12, this is similar language to what's on page 3 regarding new owners not being subject to a prior lien. That language would be stricken for mineral production after January 1st, 2021 as well. The staff comment, Mr. Chairman, on page 5 just notes that, and this would apply too for production, but assuming that this bill is considered in the general session and takes effect on July 1st, 2021, there would be a 6-month period where the language that is being stricken would be in effect. And so the question would be, does that need to be accounted for in this bill draft in terms of, should there be basically a hard stop and a new line on July 1st, 2021 to account for these changes? And then, Mr. Chairman, the language on page 5, line 15 is an alternate version that was suggested. This is a carryover from the bill draft that was looked at in June, and just clarifies that a new owner is not subject to a prior lien if the county holds no liens that are otherwise imposed on that person. And then page 5, line 37, this just strikes reference to a tax sale for notice of intent to foreclose. It just says that in order to foreclose a tax lien, the county treasurer must file a notice of the intent to foreclose. The bill draft would take effect July 1st, 2021. With that, Mr. Chairman, I'm happy to answer questions.
Any questions of Brian? Any questions of Brian on the bill draft? Oh, yes, Co-Chairman Greer.
Yeah. Oh, thank you, Mr. Chairman. Just a couple of things, Brian. I want to sort of make sure we've got this as an overview, and then I have a more specific question. But we're basically dealing with 3 issues here. One is a transfer of the properties, okay, or of the oil field or the coal mine, right? And what we do regarding that lien will stay in place. You cannot go to the county or get a release. The private parties have to make sure that that is taken care of in their documents. That'd be the first issue. Is that right?
Yeah, Mr. Chairman, Chairman Greer, under the current law, that's correct. What this bill draft would do is strike that language out.
Okay. The second one is the issue of the phase in on priorities, meaning that in the current legislation, the way it sits today, is in after anything that's filed after January 1, 2021 is inferior to the ad valorem lien, but anything that's been filed before that's in place right now would continue with their priority till it expires. That's the second issue, right?
That's correct, Mr. Chairman.
And then the third issue is opening up and giving the counties more remedies rather than just the limited remedy of a for tax sale. Is that correct?
Mr. Chairman, that language that's stricken on page 5, line 37, I believe accomplishes that intent.
Okay, I just want to make sure we're correcting or trying to fix a couple of things here, and then there's maybe a couple more that we'll hear about that are maybe in dispute. So, okay, thank you.
Other questions of LSO, Senator Rothfuss?
Thank you, Mr. Chairman. Mr. Chairman and Mr. Fuller, just following up on Co-Chairman Greer's question, just trying to get some before and after clarification. I think I understand what all of the 3 points do, but and why we're moving forward, but I think it would be helpful just in plain terms to sort of describe in particular regarding the lien priority, what is changing as a result, particularly of what we're doing on page 3. So can you just walk us through so we all understand the before and after lien priority for the county as a result of the changes?
Yep, Mr. Chairman, Senator Rothfuss, that change is page 4, line 10. And so the current status is that, come January 1st, 2021, for mineral production on and after that date, a county lien that comes into being from that production is superior and paramount to all other liens except any superior lien that exists before January 1st, 2021. So what we are doing in this bill draft is striking that line to where this just flatly says that the liens on the 2021 mineral production, those liens are superior to all other liens.
Thank you, Mr. Chairman. I think that's the clarification that I wanted to make sure everyone understood, and that's my understanding of what the intent was, is to ensure that we don't have the confusion of the prior superiority, and that from that point forward, all mineral production, the first most superior lien will always be the counties. Is that correct, Mr. Fuller?
Mr. Chairman, Senator Rothfuss, I believe that's correct with the change in the draft.
Perfect. Thank you. That's how I understand it.
Other questions? Other questions of Mr. Fuller? Representative Burkhart.
Thank you, Mr. Chairman. Brian, again, would you go over the dates? Because I'm confused. If you look at the effective date is July 1, 2021, but we say this goes into effect January 1 of 2021. So we're kind of post-dating the effective date?
Yep. Mr. Chairman, Representative Burkhart. So in last year's bill, in Senate File 139 from the budget session, the way that these liens were structured is to basically separate mineral production before January 1st, 2021, and that's page 2, lines 12 and 13. And then production for on or after January 1st, 2021. That's page 4, lines 4 and 5. So that's kind of the delineation between production. The staff comment on page 5, I think, gets at the question you're raising, which is, for 6 months, there will be mineral production that occurs under the current language in that statute. Come July 1st, 2021, the effective date of this act, for example, we're striking that line regarding the superiority of liens. And so that is something, that I did highlight in that staff comment for the committee to consider what is the effect of really the effective date of this act, and how liens on production between, say, January 1st, 2021 and July 1st, 2021 would be treated.
Other questions? Other questions? Representative Greer.
Yeah, Mr. Chairman, and we'll probably get into maybe a little more debate on this, but while we're listening to comments, and we've got Mr. Fuller, if I see this correctly, and I say if that section goes through where we strip out the prior liens in their superiority, you're really only talking about actions of foreclosure. Once you get to July 1st, 2021, it's really not going to matter. It would just be as a result of any action or foreclosures or bankruptcies that would occur during that 6-month period. Is that, am I looking at that right, Mr. Fuller?
Mr. Chairman, Chairman Greer, I think that's right. I suppose, really the only question that I could see arising is, if there is some sort of action, would a party argue that the law that should apply, if the lien, was perfected, say, April 1st, 2021, whether that law as it existed on April 1st, should be the law the court applies. It's hard to speculate because it's hard to contemplate if a party would raise that argument.
Yeah.
Other questions? Representative Henderson.
Thank you, Mr. Chairman. Mr. Chairman, I guess one question I have is going back to what Chairman Greer was referring to is, just how big of a issue is this? I mean, is this something that's really happening a lot? Or can you help me with the understanding the why leading up to the bill in terms of the frequency expected or experienced? Thank you.
I guess from memory, Campbell County had quite a few issues with this on multiple minerals. And I think they would like to see something done that the county is a priority. I'm not sure about other counties, but I know they had issues with multiple minerals. Other questions? Senator Rothfuss.
Thanks, Mr. Chairman. And just to follow up on your point, Mr. Chairman, for a few of our counties, you'll recall that it's totaled in the tens of millions of dollars of tax revenue that will not be received by the state of Wyoming because we do have an inferior lien position to other creditors as they're working through various credit issues. So because of those losses to the state, again, tens of millions of dollars, we worked on this issue over the last couple of years and particularly last session to develop legislation that would provide us with a superior lien position so that we would be first in line, so to speak. And this is a cleanup of what we did last year, where we ran into some concerns based on how it was structured, where there was some ambiguity and challenges with liens prior to 2021 that would still have a superior position, even though the county lien was in a first priority theoretically from that point forward. So this legislation is a policy change, but a cleanup of some of the concepts. We'll hear clearly in testimony that there are some concerns about it, and I trust we'll have, but I hope that helps to clarify as well as Mr. Chairman's discussion, the interests and concerns of Representative Henderson.
Other questions? Welcome, Senator Wasserberger. Glad to see you here. I think the only counties that have had trouble with this is counties that have had bankruptcies in the mineral industry. And that might be limited to a few counties in Wyoming, but it's certainly a big deal when it happens and they aren't able to collect their tax liens. No other questions? No other questions? Do we have some public testimony on this? I think we do.
Mr. Chairman, we have Scott Meyer, Jeremiah Ryman, Barry Crago, and Pete Obermuller.
Oh, wonderful. Do you want to bring them all on, or are you bringing them on one at a time?
Mr. Chairman, they are in the meeting currently.
Oh, good. Okay. Okay, why don't we start with Mr. Meyer?
Thank you, Mr. Chairman, members of the committee. Scott Meyer with the Wyoming Bankers Association. We stand in support of what the bill has done with respect to the counties and the enforcement provisions. We think that that makes a lot of sense. With respect to the priority of the liens and when that date becomes effective, however, we disagree and strongly oppose this. As you might imagine, there are numerous number of lenders who have lent on the presumption that they have a secure lien. And to make that kind of a change now at this point would severely limit the ability of these lenders to, to enforce those provisions in their loan documents and their security interests. I can't imagine this thing going out much longer. I know that there has been some discussion a little bit regarding the, how long would this last type thing. And I will tell you that it's been my experience, although I can't say definitively, but that these commercial loans, which these are primarily are, will probably last, at the most 5 years. That's just generally where commercial loans last. And so the state would have its priority after these loans get through. But I think it would put your community banks at a severe disadvantage if all of a sudden they lost a priority that they had lent money on with respect to those loans. Now, I think also then it also creates probably a little bit of havoc with our regulators taking a look at these and trying to make sure that the loans are what they are and on the books, and then whether they're properly secured or not. And finally, I would just say, I think it sets a dangerous precedent for the sovereign to come in and say, I know we've had these rules, but we're going to change these rules. And I understand we're in a budget crisis and there are counties that are in equally as budget crisis, and they're looking forward to this revenue that they desperately need. But I do think it sets a very dangerous precedent to step out there and say, I know we played by a certain set of rules and we're going to have priorities listed first in time, first in right type things, but we're now going to change those. And so for respect to the priority of those liens, then the Wyoming Bankers Association strongly discourages that and is not in support of that issue. I'll stand for any questions, Mr. Chairman.
Mr. Meyer, the issue you're talking about is that striking that line on page 4. Is that what you're talking about that you don't like, or you don't like the whole bill?
No, Mr. Chairman, we don't like the provision on line 4 that strikes, that takes out that priority. The rest of it, we're in support of.
Okay. All right. But do you have any ideas for solutions for our January to July dilemma?
Mr. Chairman, I really don't. I don't know which counties are affected. I do think that that's probably going to be an issue, as you had mentioned, with respect to those counties where we do have a number of bankruptcies regarding the mineral industry. But I will tell you my own humble opinion that the state will experience a lot more bankruptcies through September and October just because of the COVID problems and everything else. So it may be a bigger issue for the state than it probably is for just a few counties.
This probably is not an issue for Bank of the West.
Mr. Chairman, I don't know about Bank of the West. They are not a member of our organization.
Oh, okay. Questions, Senator Rothfuss?
Thank you, Mr. Chairman. Mr. Meyer, what is the dollar value of credit roughly that is affected? In other words, there are only certain extended credit that would be affected by this statute. Some of it's coming from national banks, international banks, and I assume some state banks. So I'm curious how much we're actually talking about where we have state banks extending credit to these mineral companies in such a manner where they have liens against production that would be affected by this change?
Mr. Chairman, Senator Rothfuss, I don't know that I can answer yet with a dollar figure. I will tell you that primarily those here are state chartered banks. We have very few nationally chartered banks here, but we mostly are state chartered. And there are only a few banks really that get involved with a lot of the mineral stuff. Many of them don't. But to the extent that those that are due, I don't have any idea of how much dollars they're looking at, but they would probably significant in the fact that that's the area that they do lend.
Follow up, Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Meyer, I think we need to understand that. I understand the concerns that state banks are bringing, but I do also understand that there's a very limited interaction, I think, in terms of what the state banks, how many are involved and what we're talking about in terms of total dollars, whereas overall lien priority has cost the state and counties tens of millions of dollars where we weren't able to recoup those taxes. So I guess if you don't have the information now and you want us to make a decision based on that, I would like to ask you to look into that and get us, it doesn't have to be a specific number where we're going to audit to it, but I would really like to understand whether this is a few $1,000,000 that we're talking about, whether this is tens of millions of dollars that we're talking about, because I think it's important for us to know that as we're making a decision on your request. Thank you, Mr. Chairman.
Yeah. Any other questions? Representative Greer, co-chairman, my co-chairman.
Thank you, Mr. Chairman. I have two questions for Mr. Meyer, and I think the first is following up on your question, Mr. Chairman, is if we leave in that language regarding the cutoff on prioritization on January 1, like the current law is, that eliminates that January, July issue. Do you read that way?
Mr. Meyer, do you? Yeah, you're on.
Yes, Mr. Chairman and Chairman Greer, yes, I would agree with you with that assessment. And, you know, I guess I'll just throw in really quick, just because I wasn't quite sure if I had a chance to respond. I will certainly see what I can do to provide Senator Rothfuss with that information. But I do still stick by the position that that is a very dangerous precedent, regardless of the dollar amount of being able to take priority over something that's already been done.
So, and then Mr. Chairman, yeah, my follow-up question. And Mr. Meyer, you just touched on my follow-up questions. I don't look at this as the dollar amounts. I look at this as a precedent. So you have, and what does this do to the banking industry? And what does it do to the ability for our banks to extend credit when you operate under a set of rules or assumptions, and then the state of Wyoming comes in and changes those rules? What effect's that going to have?
Mr. Chairman and Chairman Greer, that is exactly the issue that I was trying to refer to, is that when we operate under a set of rules and we believe that we are going to lend money with respect to a project or what have you going on, and we know that we have a security interest in in an asset of some sort that we're able to rely upon if that loan is not paid, and then to have those rules changed will create havoc, I believe, in the banking industry. It will not only create havoc with the lenders themselves, but the regulators themselves, but it will also create havoc with respect to the lenders, because they won't know what they can count on and what they can't. The result probably will be is that they're going to require probably over collateralization on loans. Not that they don't now to some extent, but it'll have to be grossly over collateralized, because we won't know what the state is going to do in order to disrupt that security interest.
Other questions for Mr. Meyer? Senator Rothfuss.
Thank you, Mr. Chairman. As I understand it, though, Mr. Meyer, just to clarify, it's not really the concern with the priority position, because you can calculate to that. It is a change in security position or lien position, excuse me, with regard to existing securities where it would be changed after that risk and the associated rates with that risk have already been calculated. So it's really not the change in position, which we did last year, that's the concern. It's the idea that we would be shaking up existing lien priorities. Is that fair?
Mr. Chairman and Senator Rothfuss, that's exactly right. Now that you've got this, you have these whatever currently existing loans, you don't mind saying, look, we understand when we make a loan that we are going to be in second position going, into 2021, but with the current loans that are out there, those are the ones that were built on a assumption of facts.
Right. Follow up, Mr. Chairman.
Yes.
We talked a little bit at our last meeting about the length of term of the credit. And I don't know that we really arrived at a firm understanding, at least I didn't, as to how long we would have to be grandfathering, so to speak, before we were fully ahead of the transition, instead of having some legacy liens out there that would be where the state would be behind in its lien position. Did you have an opportunity to look into that more and give us a better sense of how long before this all sorts itself out?
Mr. Chairman, Senator Rothfuss, I did, and in my, of course, I don't have a list of every single loan that's out there, but the general idea that I'm receiving from my members is that these commercial loans last no more than 5 years before they're either refinanced because of interest rates or changes in other terms. So I think you're probably looking at least at a general area of 5 years before the state would know that everything has been kind of flushed through there.
One more follow-up, Mr. Chairman. if I
One more
may.
follow-up.
That again is something I feel like we would really benefit from understanding that. And it's my understanding also that we wouldn't have to worry about revolving lines of credit or anything along those lines as well, and that we could get our lien priority position shifted under those circumstances as well. So I just want to make sure that if we do end up finding a way to change this so that we are not reconfiguring lien priority for existing lien obligations, that we don't end up with 10 years down the road saying, hey, well, we really should have addressed this because this is a priority that's still out there. So again, I'd ask maybe a little bit more digging to make sure that we're not missing something there on those outstanding liens. Thank you, Mr. Meyer.
Thank you. Senator.
Mr. Chairman, Senator Rothfuss, I certainly will take a look at that and get you what information I can.
Thank you, Scott. Representative Duncan.
Thank you, Mr. Chairman. Mr. Meyer, my concern that I keep hearing, and it's a very big concern of mine, is you keep bringing up regulators, and my background is real estate, and we're constantly struggling with this with regulators and lending and things like that. So the theme I'm hearing is you're concerned about the goalposts continuing to be moved when times are hard. So the precedent that you're worried about and concerned is that every time that there's an issue and a problem that we're going to continue, the state's going to come in and continue to move that goalpost. So is the 5 years the only issue with the commercial loans that are out there right now, or is there more of a concern, a bigger concern with other issues and other problems that you foresee maybe in the future, or other things that we're not looking at?
Mr. Meyer, do you want to address that?
Yeah, Mr. Chairman, Scott Meyer here. I will, Representative Duncan, I will tell you that I do think that is, the 5 years is kind of an idea of where I think those commercial loans are. But I do believe that from a fundamental standpoint, you're exactly right, that what we're trying to do is we don't want to have the goalpost shifted. I don't know about how this thing is going to shake out into the future, but that will allow businesses to do what they have to do to negotiate either the rates or the terms of the loans or whatever, knowing full well that they are not going to be in first priority on those particular assets for security interest. I will tell you that it just seems to me that in businesses in general, it doesn't make a difference what issue we're talking about, whether it's liens or whether it's taxes or what it is that's out there. Business in general can deal with about anything that you give them as long as they understand what it is that they can deal with. And if the goalposts keep shifting, as you say, then it makes business very difficult for businesses in general to understand how they're going to do business. So give me a set of rules. We will figure out a way to work through those to make it a profitable venture for everybody involved, and we'll move forward with it. But if you change the rules in midstream, then I have a very difficult time saying, boy, we can bank on this, but we maybe really can't because now we don't know where we're at.
Question, Senator Beitman.
Thank you, Mr. Chairman. Mr. Meyer, I'm going to piggyback on that. My question is, what has this done to the cost of capital for mineral companies that need this money? Is it going to make their access to capital more difficult? And is it going to make the cost of capital more difficult or more expensive?
Mr. Meyer?
Mr. Chairman, the answer is that I'm not sure, but I do think that it will increase the cost of capital because it'll increase the cost of lending in order to get whatever you need to have, because we won't know what we have as for a security interest in this. I will tell you that I've had conversations with my counterparts over in mining and in oil and gas, and I try to understand, how this will affect their members and our customers. But the general idea that I'm getting is that they want to have the same set of guidelines that the banks are having, so that they know really what they're dealing with. And that's where I think it could very well affect the cost of capital, because now if you have to go out and borrow and the risks are now greater because we're not in a priority position, that causes interest rates to go up. I think that has a definite impact on all borrowers in this industry.
More questions for Mr. Meyer? More questions? Just so we all on a level playing field, the larger companies are not borrowing from state banks. They're borrowing from international banks, insurance companies, GE Credit, et cetera, huge enterprises. In the ones that I'm familiar with that have declared bankruptcy, then the state banks and the smaller banks in Wyoming lend to the suppliers. And the suppliers don't have a lien on their property like the producers do. So it's a little different deal, but I can see what Mr. Meyer is saying about don't be changing the rules of the game. Senator Wasserberger, did you have a question?
Mr. Chairman, you answered it with your last comment. Thank you.
Okay, any other questions? All right, thank you, Mr. Meyer, for your testimony.
Thank you, Mr. Chairman.
Next up, I think I saw Jeremiah Ryman on there. Oh, there he is. Yeah. Let's go with Jeremiah.
Good morning, Mr. Chairman. Good morning, members of the committee. My name is Jeremiah Riemann. I'm here on behalf of Wyoming's County Commissioners. Appreciate the opportunity to address you at this issue today. I am joined by Barry Crego, who is the Civil Deputy County Attorney for Johnson County. So if we get into some technical issues, some county level issues, he certainly can be available to answer any of your questions. Mr. Chairman, I did want to just address a couple of the discussion points before I get into the three components and our perspective on those. There was some discussion about how many counties are we talking about. When we looked at the number of counties that have experienced some loss of mineral ad valorem, or at least had some delinquency in this arena, we found that all but 3 counties, those 3 counties being Goshen, Platte, and Teton County, all of the rest of them have had some sort of a mineral ad valorem delinquency over the course of the past decade of varying degrees. And I don't want to get into the deep data around that, but And I don't have a firm answer for you of how many have had this bankruptcy issue, but it has hit a number of them, and some of them in rather large and dramatic ways. Mr. Chairman, to Representative Henderson's question about companies, just in the time period since you left session, we've had two major companies with interests in Wyoming declare bankruptcy. And I don't want to suggest that they aren't going to come through that process without paying their debts, their tax debts that are owed in this period. But those two major companies could, depending on how proceedings go, could impact tax revenue. And we do, as Mr. Meyer suggested, expect that there will be additional bankruptcies through the fall and continuing into the future. So, Mr. Chairman, as has been referenced, there really are three issues that are addressed by this bill. And as you've heard in testimony so far, two of those, from our perspective, we believe are non-controversial amongst other interested parties. And then, of course, we have this issue around the timing. So, Mr. Chairman, I'm just going to go quickly through those issues. The first comes up on page 3. It also comes up on page 4. And that is around this issue of certifications. What we are concerned about is that the current language makes it possible for a company to come to a county treasurer's assessor's office, obtain a certification that all taxes to that date are current, and then as a result of that, get a pass on what otherwise is a lien that the county, the state, and others might hold. The problem is that that's a certification from that point in time and doesn't take into account the fact that those companies that may have received that certification will have an outstanding tax debt at some point in the future. Remember, our mineral ad valorem tax structure is roughly 18 months behind. And so what we're asking is to delete that language and remove it. It doesn't materially change anything for those transactions. It just ensures that we don't get in a situation where a company would then claim that future mineral ad valorem isn't due as part of that transaction. We did offer some alternative language to that issue that does show up in the LSO staff comment on page 5 on lines 27 through 30, if that's a more preferable way to go. But that's really what we're trying to address with taking out the language that again appears on page 3 and page 4. Mr. Chairman, I'm going to skip over the second issue and go to the third, and then I'll come back to that second issue. And so I'm going to jump to page 5 and the language that we're asking to be stricken on lines 37 and 38. Co-Chairman Greer was spot on in what we're trying to accomplish there, and that is to ensure that foreclosure actions aren't always tied to a tax sale. There are other means that a county has for foreclosure, and we don't want to get it tied up with this tax sale language that is currently there. So I think that's again another non-controversial portion of this. Mr. Chairman, I'll close on the issue that really is at the heart of this bill that we have some disagreement over, although I've had good conversations with Mr. Meyer and others. And I do think that we can find a path forward here. I want to be really clear. our goal isn't to change the, where the placement of the goalposts are. We want that to be clear for businesses in this state. We want our bankers to be strong and to be whole as part of these bankruptcy proceedings as much as anybody else. What we're trying to seek is to ensure that the counties know where the goalposts are. Under the current language, there is no clear line of demarcation. You could say that January 1st, 2021 is a line, but as we've heard in the discussion here and in the past, counties don't know what the liability is relative to the length of the term of these other creditors that might exist out there. And maybe that's 5 years, as Mr. Meyer suggested. Perhaps it's longer. And so what we're trying to do is to find and establish those goalposts, to establish a clear line of demarcation at which counties can be assured that they are going to be the superior lien holders here. And remember, when we're talking about a bankruptcy proceeding and county tax obligations, really the county only takes about 17% of that. The rest of that money goes to other special districts, and the vast majority of it goes to our education system. So we really want to have that clear line of demarcation. And more importantly for the counties, the courts need that clear line of demarcation so that they can make good decisions about how to settle these tax obligations. I did want to just quickly talk about the cost of business. Again, our intent is not to try and disrupt the cost of business. It isn't intended to disrupt the activities that go across this state. And we can look to other states who have done this very thing. In fact, Texas in 1982 gave a super priority to its governments. And I think we could all suggest that Texas is a very business friendly, a very oil and gas friendly state. And so perhaps what we've suggested in terms of deleting the language on line 10, page 4, is not perfect, but I would just ask that the committee continue to work with us. We'll work with all of the parties to try and find what is that appropriate goal setting in all of this transaction. So with that, Mr. Chairman, I'd be happy to stand for questions.
Any questions for Mr. Ryman? Representative Duncan.
Thank you, Mr. Chairman. Mr. Ryman, can you give me your brief opinion about the language on page 4 versus the Bankers Association wanting 5 years?
Yeah, Mr. Chairman,
yes.
We're Representative Duncan, 5 years could be a clear line of demarcation that could exist in here. I think you still have to have that initial line. So a January 1st, 2021, a July 1st, 2021, something that is the initial demarcation. But I think what should be in there, and maybe that's the discussion point, is that definitive line at which, regardless of the situation, counties, the state, our schools and others are in the priority position.
Other questions? Other questions for Mr. Ryman? Other questions? None? Thank you, Mr. Ryman.
Thank you.
Thank you. Thank you for being with us today. Next up is Barry Crago, Citizen Crago. So far, we've got a general election to make it through, and he might be with us. So, Barry Crago, go ahead.
Thank you, Mr. Chairman. I don't have a whole lot to add to what Jeremiah already said. I think he did a good job setting forth the issues that are important to the counties. And the only, I guess I would add one little comment, and that's as you think about this, and this might be, a good question for Mr. Meyer actually, but, most financing agreements actually have provisions in there regarding taxes. When any of us go buy a home, the county has priority on that home, no matter what. We have priority on those taxes because we can do a tax sale on that home. And so what we're asking for is the same sort of priority that in the mineral side that we have on, for instance, your home, my home, anybody's home, or any other property, any other real property for that matter. And so my guess is most of these financing agreements and to Senator Rothfuss's questions earlier regarding, who actually has the financing agreements on all of these loans. My experience has been it's typically companies we've never heard of, out-of-state investors, out-of-state banks. You're not seeing your local banks on those agreements. But back to my point, those agreements most likely have a tax provision in there where the bank can go and pay those taxes if they need to, just like they can on our house. I mean, we all have escrow agreements that when we go borrow money on a home, we have an escrow agreement and the bank uses that money to pay the taxes. And so I'd be interested, and I don't know that, and that's why it's probably a better question for Mr. Meyer, but it's something the committee may want to look at, is what effect will this really have on those financing agreements if they have the ability to collect that money and pay the taxes anyways? I don't know the answer to that, but other than that, I don't have anything to add to what Mr. Ryman had. He did a great job, and I would stand for questions. Thank you.
Any questions for Mr. Crago? Any questions? Yes, Representative Henderson.
Thank you, Mr. Chairman. My question for Mr. Crago is, if my understanding is correct, the biggest issue we've had recently is bumping up against the bankruptcy specifications at the, outside the state in terms of the federal implications. So from your perspective in the county, how do you see this fixing that? I mean, we can do everything that we do, and maybe we aren't moving forward. What would you say to that?
Mr. Crago?
Mr. Chairman, Representative Henderson. So when you go to bankruptcy court, the bankruptcy court is required to look at state law regarding priority. That's how they determine who gets paid. And so whether we're in a Texas bankruptcy court or a Wyoming bankruptcy court, our priority language will still control how that works. Now they have to balance that against other priorities from other states and other lien holders. But in regards to that, the interests that are in Wyoming, oil and gas interests, we would have priority against those, no matter where the bankruptcy court is.
Other questions of Mr. Crago? Other questions of Mr. Crago? Hearing none, thank you, Mr. Crago. We look forward to working with you.
Thank you, Mr. Chairman.
Next up is Pete Obermueller. I think he might still be there. He is. He's there.
Morning, Mr. Chairman. Members of the committee, thanks so much for having me this morning. Pete Obermueller, President of the Petroleum Association of Wyoming. Appreciate the time. Also pleased to see that my friend Mr. Riemann got the memo about a plaid tie. Just mark that as a symbol that we have a lot more in common than otherwise. So we really value our relationship with the counties and with the WCCA in particular. And so just want to say that at the outset. Mr. Chairman, as it relates to this, very similar to Mr. Meyer, in a sense of we don't oppose the bill, don't oppose 2 of the 3 changes, have a little bit of trouble with taking out the line on page 4, line 10. Mr. Chairman, just a little brief history. The Petroleum Association opposed making any changes to this statute for many, many, many years. It was a long-standing opposition for a lot of the reasons that were mentioned already regarding cost of capital and all of that. 2 years ago, Mr. Chairman, we dropped that opposition as a result of what we saw, particularly going on in other industries and the unpaid taxes based on delinquencies. So we dropped that opposition in favor of the policy choice of making sure that lien statutes were, basically favored the counties, and so that taxes could be collected, believing then 2 years ago, as we still believe, that will have a greater impact on being able to collect taxes than any other effort that's currently underway. But Mr. Chairman, we did that knowing that it would in fact increase our cost of capital, not access so much, but costs. And you mentioned, Mr. Chairman, that a lot of service companies are ones that have financing agreements with state banks. And that is likely true. But keep in mind that when Mr. Meyer's members are looking to provide financing agreements to service companies exist to service the oil and gas field. If the oil and gas field is on its knees as it is today, their cost of capital will go up. And who do oilfield service companies pass along those costs to? E&P companies. So as a matter of policy, making sure that the counties have a priority lien is a position that PAW is okay with. But we do it, and we ask you to do it, understanding that it does in fact increase our costs, both for E&P and for our member companies that are service companies. Add that on top of the increased cost that the change in ad valorem is imposing. And, we certainly have in these two areas an increased cost going forward. And I would just ask, with respect to that particular line, that, one of two things. Most importantly, that we give these two laws that are already on the books time to work themselves out while my members get back up off of their knees. And two, perhaps if there's more to be talked about with respect to an actual date that would work for the bankers and the counties and for my members, that perhaps we just table it as is and we continue to talk about it. It seems to be a lot of openness there, and I'm certainly open to keep talking about that as well. But Mr. Chairman, if the bill moves forward today, we would prefer that the line on page 4, line 10, not be stricken.
Mr. Obermuller, you're saying you prefer it not be stricken? Is that what you said? You'd like to leave it in?
That's correct, Mr. Chairman. We would like that clear line of demarcation so that, as Mr. Meyer pointed out, the goalposts aren't moved. With respect to that, I would say that I understand, and Mr. Riemann makes a great point with respect to not wanting the goalposts moved for the counties. I get that. The trouble there is, of course, without pulling every single financing agreement from every single member affected by this, which of course is an impossibility. These are private arrangements. There's no way that we can get the data necessary to find an exact date, and there won't be an exact date. We have to pick one date and move forward with it and make progress on it. We have to start somewhere, and we've started somewhere with this bill and with other bills, and we can move forward with that.
Okay. Any questions for Mr. Obermuller? Any questions? Any question? I guess not, Mr. Obermuller. Thank you very much for your testimony. Thank you for being with us here today.
Thank you, Mr. Chairman.
Thank you. Okay, is there any other public comment? Is there any other public comment? Mary Beth, is there anyone else waiting in the room? I can't see waiting in the room. Oh, they says there's 2 people.
Mr. Chairman, those are on the next topic.
Oh, are they? Okay. Okay, we'll close public comment then. Committee, what's your pleasure? Representative Duncan.
Move the bill.
Moved by Duncan, seconded by Coe. Any discussion? Any discussion? Representative Greer.
Yeah, thank you, Mr. Chairman. This issue on ad valorem and how the bankruptcies affected counties, it's been around for a lot of years. And this matter, I think, had been in front of the Revenue Committee 3 years in a row. If we look back about 5 years. With the coal bankruptcies last year, a select committee, I think Senator Rothfuss served on that. I think he's the only one in this committee that did. They looked at a lot of issues. And so what came out of that in the session last year were some bills from that committee that got reworked rather hard. But what it did is it brought all the stakeholders together to discuss a reasonable path forward. And one of those, if you'll recall, is the very complex, but I think slightly workable prepayment or payment when due of ad valorem. This tax lien bill had some issues as it came out, and Senator Perkins and I spent a lot of time working on this. And just because we spent time working on it doesn't mean anything. It just meant we thought it was serious and it was part of the equation. What we passed last year really helped the counties significantly. And what I find as we look at it, looking back, is there were a couple of areas that were problematic. One is the third issue we talked about regarding remedies. We were trying to find a streamlined, smooth remedy by just having it tied to tax sales. I realized at our last meeting when we reviewed this issue that we should leave all remedies on the table for the counties. And I think that's a good change. And that's why we need to continue to work this bill. The second component regarding the certificate of taxes is very problematic for the counties. And I can understand that can easily be dealt with contracts, with escrow arrangements and so forth between the parties. And I think that is a good change. I struggle strongly, having heard the history over time, and where it truly was in my opinion or my assessment of what happened, this January 1 date was a compromise. That was the first time we were able to put a stake in the ground. What we're saying is going forward after January 1, okay, unless any lien or any type of loan that's given after January 1, we know that it's going to be inferior or subordinate to ad valorem. People go in knowing that. Does that change the cost of capital? It could. But we've all agreed that is a good path forward to make it clear. The issue was with those liens that were filed prior to January 1, okay, 2021, the people that entered into those agreements at that point in time, are we going to come in as a state and direct those, rewrite those contracts, affect those relationships? And so the answer as the law sits here today, okay, without the language being stricken, is we said, no, we're going to leave those alone, but we are going to do better going forward. And so I just wanted that little bit of the history. This is my view. This is open discussion time. I would like to see us correct item 1 and item 2, and I would like to leave that priority alone. So that's my comments, Mr. Chairman.
Mr. Co-Chairman, is there some reason we couldn't make it January 1, 2022? Would that solve some of our problems?
So, Mr. Chairman, I think that would make things worse for the counties. Taking that date out, we've been talking about January 1st, 2021 now for well over a year, by a year and a half. I think if we move it out, all that does is put the counties in a worse position. I would just like to leave the bill as is. If we pass that bill out, and if there is a discussion on an interim period, like we were talking about 5 years, and it comes up during the session, I'll keep an open mind about it, but I don't see us doing that today or during this interim.
Representative Furphy.
Thank you, Mr. Chairman. I am very concerned on line 10 on page 4. I don't think it's fair to the banks to change what they had in the past considered a priority lane. And now we as a state are taking that out. So that's the only part of this bill that really concerns me. So I'm going to propose an amendment to reinstate the stricken language on line 10 on page 4, so that banks know they have a superior lien, and they also know as of January of 2021, their liens may not be superior, but at least they know where they're at this point. So I make that motion, Mr. Chairman.
Murphy makes a motion to eliminate the striking of line 4, page 10. Is there a second? Is there a second?
Yes.
There's a second from
Second.
Beitman.
Mr. Co-Chair, page 4, line 10.
Yes, page
Okay.
4, line 10. Yeah. All right, any discussion? Any discussion on the amendment? Any discussion on the amendment? Hearing none, sensing the body is ready to vote, the motion is to take the strike off out of line 4, page 10, and leave it in the bill. All in favor, signify by saying aye.
Aye.
Oh, raise your hand. Yeah, that'd be better. All opposed, same sign. Raise your hand. That amendment has carried.
Mr. Chairman, just for the record for LSO, and to be clear, you did say page 10 again, but it's page 4, line 10, correct?
Really?
Yeah.
Really? Must be something wrong with my computer. It must be something in the computer doing that, changing my page 4, line 10. Thank you.
I know.
And Senator Coe, you had something. No, Senator Rothfuss.
Thank you, Mr. Chairman. And I supported that motion, and I think it makes the bill cleaner and gets the important changes addressed. But I just do want to raise a concern that I still have with regard to making this change. First of all, we'll be putting in place a potential window of opportunity now where if this legislation goes forward, there might be an interest or a rush to refinance credit before that date, effectively in such a way where you've got long-term credit, where you've got a priority lien in position. It was a concern I had before. This clearly leaves that opportunity open. The second concern I have is we really have no idea how much money of state banks this actually affects, which I've asked that question several times and keep getting yeah, it makes a difference, but I haven't heard the difference yet. So I feel like we're probably bending over backwards where there really isn't any state bank credit extended, but I do understand the idea that we don't want to be changing parameters that have already been negotiated. I respect that and I support that concept. And then the final concern, though, is the idea that nothing precludes then a lien being put in position on a long-term line of credit or a long-term credit, particularly now that this is going to go in place without this exclusion. So we might end up with outstanding lines of credit, again, not to state banks, but to national banks, that could put us in a situation where we are inferior in the lien position on significant amounts of credit extended because somebody's going to take advantage of the fact that we're leaving a loophole in place. Those are the same concerns I had before. This is a discussion that is not the first time we've had this discussion. I don't have any easy answers. And honestly, I don't want to muddy up the bill because I think the other two changes are important enough that we're better off moving this forward clean. But it is something to continue to think about. We might be leaving some loopholes and concerns in place, and I hope we don't. Thank you, Mr. Chairman.
Thank you, Senator Rothfuss. I understand your concerns, but I think the minerals industry is having enough trouble getting loans from international bankers. A lot of them won't loan anymore. Bank of the West isn't the only one that won't loan to mineral industries anymore. So I don't know whether we're going to have huge loans out after January 1st, 2021, that we're sure going to have taxes out after that time. Any other questions? Any other discussion? Any other discussion on the bill? Any other discussion on the bill? Hearing none, sensing you're ready to vote. We're voting on 21 LSO 0071 .4 draft tax lien enforcement amendments. We're voting to move it out of the committee. All in favor, raise your hand.
Roll call.
Roll call, Mr.
Roll call.
Yeah.
Roll call.
White.
Mr. Chairman, this is a roll call vote on 21 LSO 0071 version 4 as amended. Senator Biden,
Do a roll
Aye.
call vote on that then.
Senator Coe,
Aye.
Senator Rothfuss,
Aye.
Senator Wasserberger,
Aye.
Representative Burkhart,
Aye.
Representative Crank,
Aye.
Representative Duncan,
Aye.
Representative Ayer,
Aye.
Representative Furphy,
Aye.
Representative Henderson.
Aye.
Representative McGuire,
Aye.
Representative O'Hearn,
Aye.
Co-Chairman Greer,
Aye.
Co-Chairman Anderson.
Aye.
That passes, Mr. Chairman.
Thank you. Thank you, Mary Beth.
I think, Mr. Chairman, as we did in the past, we'll sit after the interim and decide which bills to send to which house. Does that work for LSO?
I bet LSO will go along with that.
It does, Mr. Chairman.
Yeah, thank you.
Okay, next order of business, are we gonna look at this consumer credit amendments here?
Mr. Co-Chair, if I may.
Yes.
Yeah, just, so we've got, so up first, right, and I guess that we got 3 bills. So these 3 bills we reviewed last time. I think 2 of them are ready to be worked. The bill regarding the substantial revisions to the Uniform Commercial Code is not ready to be worked by this committee. And I say that because most of the stakeholders have visited with me about it. And I think the division, Mr. Forkner, the commissioner of the banking division, agrees with that. And so one of the things I would like for us to do is go ahead and punch through the other 2 bills. But with the Uniform Commercial Code is maybe have Mr. Fuller give us a 30,000 foot overview so that we are familiar with what is going on. And then Mr. Chairman, I would propose that we do and set up a select committee and or just a subcommittee to work on this so that it is ready, because we have one more meeting left. And if we're going to move it forward, I want to make sure we have some subject matter experts. On the House side, Mr. Chairman, I would gladly volunteer or appoint Representative Duncan and Representative Henderson to work on this. And then I also, not to have it too big, but Representative O'Hearn probably needs something to do, Mr. Chairman.
I bet he appreciates that. Yeah. Yeah. So Brian, do you want to give us an overview of this? And I'll be looking for volunteers from the Senate if anybody wants to sit in on this.
So, Mr. Chairman, you want me to start with the consumer credit bill?
Yeah.
Okay. All right, Mr. Chairman, this is
30,000 footer.
You bet. Mr. Chairman, it's 21 LSO 65 consumer credit amendments. In short, what this bill does very broadly is that it amends and consolidates various provisions regarding consumer loans, consumer-related sales and loans, and supervised loans. There's also provisions that authorize the commissioner to make monetary value adjustments for inflation. That's right at the beginning of the bill. That's pages 2 and 3. There's a staff comment to go along with that. The bill also exempts supervised financial institutions from certain notice requirements. It provides language for requiring certain refunds in the event of prepayment, if prepayment is made on certain types of loans or products. It provides calculations for payoffs. It makes changes to the authorization for activities for specified licensees, particularly regarding sales finance activities. And then it also tweaks the language regarding loans that are primarily secured by interests in land, basically streamlining that into other sections and repealing those sections that deal exclusively with that. This bill draft also repeals a number of provisions. Those all begin on pages 32 and 33. But just to summarize, it repeals part of the definition of what a supervised financial organization is. It repeals certain definitions for whom the substantive provisions are being repealed. It repeals provisions related to consumer-related sales, language for loan finance charges, which is reinserted in this bill draft. It repeals provisions related to supervised loans, consumer-related loans, and then certain provisions regarding fees and notifications, as well as provisions regarding how the act takes effect, which refers to, which are sections that specify how the act came into being in 1971. So those are being repealed as well. That is a very quick and very broad overview of what this draft does. I'm happy to answer questions about specifics.
Any questions on specifics on the bill? Obviously, you're going to hear a lot more about this in our next meeting. Is there a volunteer that wants to be on the committee to, Senator Rothfuss would like to be on there.
I don't know if would like to is accurate, Mr. Chairman, but I raised my hand.
You're a volunteer. You are a volunteer, Rothfuss. You are a volunteer.
And Mr. Chairman, on the House side, we're not quite so, I'm just going to appoint people. So Representative Duncan, Anderson, and O'Hearn will be appointed to that committee.
Okay, in our committee will be a volunteer. Senator Rothfuss. We're not quite so. And I guess you need to get with LSO to find out when we're going to meet and what you're going to do and things.
Yeah, well, I think Mr. Chairman, I visited with Representative Duncan about this. I think she can get with Senator Rothfuss and they can take the lead on this. It needs quite a bit of review and work with the stakeholders. And so I trust with that group. It's a good group. Mr. Kocha, the one thing I'd be sensitive to is I believe Mr. Pickard and Ms. Allen may have signed in to comment on this. And so even though we're pushing this down the road, they're maybe taking comments from them would be appropriate if they still wish to comment on the informed.
Is that, Mary Beth, are they wanting to speak on that?
Mr. Chairman, I believe so.
Okay. All right. Well, let's go with Mr. Pickard.
Good morning, and thank you, Mr. Chairman, members of the committee. My name is Dave Pickard. I'm representing two clients today, the Mountain West Credit Union Association and the Guaranteed Asset Protection Alliance. We have spoken with the banking division, Mr. Mulberry. We have also spoken to Co-Chairman Greer. We support looking at this further. We understand the intent on what the division is wanting to do when it comes to these credit insurance and gap waiver products. We just want to make sure that the language is consistent with what is adopted in other states. So we look forward to working with you and working with the subcommittee to bring the appropriate language Not very controversial. I think we're all working towards the same end goal here, which is a consumer protection language within the code. So with that, Mr. Chairman, I would stand for any questions, and I thank you for your time.
Any questions for Mr. Pickard? Any questions for Mr. Pickard?
Just Mr.
Just one.
Chairman, yeah, I just want Mr. Pickard to know, yes, I did make the putt and I parred that hole. So I took this call while I was on the course last night.
Well, Mr. Chairman, I'll let you know that I bailed off of number 6 because my game was going nowhere last night. Thank you.
Okay.
Thank you for that update, you two. Marcia Allen, would you like to speak to us about this bill?
Good morning, Mr. Chairman. Marcia Allen with the Wyoming Automobile Dealers Association. Since this is going to be moved forward, I really won't comment today. I have been working with the banking division. Look forward to working with all of you on this. It is very complex, and honestly, every single time I read it, I end up having more questions and concerns. So moving forward, I really just look forward to working with you all and getting something that we can all agree with. And I would answer any questions.
Any questions for Allen? Any questions? Any questions? Hearing none. Thank you, Miss Marcia Allen. Thank you for your comments today. We look forward to working with you on this bill. I think that's all the public comment that I see on this bill. So that's what we're going to do with this bill, is move it on to the committee to study on it a little bit. Next order of business is the banking division, and we have some bill drafts for the banking division. Staff, do you want to go over? There's 2, I guess, on this group. The trust company.
Mr. Chairman, I can start with that one. Mr. Chairman, committee members, 21 LSO 1, draft 0.5 trust company amendments. This is based on the language that the Division of Banking provided to the committee at the meeting in June. In summary, what this bill draft does is provides procedures for the mergers and acquisitions of trust companies. It amends the composition of the state banking board to include members who are associated or connected with public trust companies. It amends the definition of trust company and other definitions, and then amends meeting requirements for chartered family trust companies. Just to walk through the bill quickly, Mr. Chairman, page 2, beginning with line 8, these are definitions for this new section regarding mergers and acquisitions of supervised trust companies. It spells out who the former trust company would be after a merger and acquisition, as well as the resulting trust company, the entity that continues after the consummation of a merger or acquisition. Mr. Chairman, the staff comment on the top of page 3, based on the definition of resulting trust company on page 2, lines 17 to 21, it specifies an entity that will continue operations after a merger or acquisition under an existing charter or other authority. The staff comment just highlights whether there's a need to contemplate that a merged or acquired company would ever operate under a new charter that would be issued pursuant to our trust company statutes. Mr. Chairman, page 3, line 19 just states that a supervised trust company seeking to acquire or merge with another company must comply with the provisions of this section. Page 3, line 25, a supervised trust company that would become a resulting trust company, so the successor entity after a merger or acquisition must apply for a certificate with the banking commissioner at least 75 days before that merger or acquisition is consummated. Language on the top of page 4 allows the commissioner to conduct an investigation or examination into the application as the commissioner deems necessary. And then the commissioner has 60 days after receiving the application to approve or deny that merger or acquisition application. Page 4, line 8 just provides what the application must include, information relating to the character of the parties to the merger or acquisition, including business operations and management, financial statements for the parties to the proposed merger or acquisition for each of the parties in the current fiscal year and the past 4 fiscal years. Moving to page 5, the final plan and terms and conditions of the merger or acquisition. All records and certifications that are under subsection F, which is basically a certification that the entities, their boards or members or managers have approved that merger or acquisition. A description of any proposed material changes to the former and resulting trust companies, including business operation and structure, the identification of any person who's compensated to make solicitations or recommendations for proposed mergers or acquisitions, excluding anyone who provides legal advice. Bottom of page 5, they have to include any copies of invitations or tenders or advertisements for making an offer to purchase stock or ownership related to the merger or acquisition, the source of funds for the proposed merger, and then any other information the commissioner requests or requires. Mr. Chairman, the staff comment on page 6 just notes that the committee may wish to consider specifying in the intro to subsection D that the commissioner has to create an application form. That's not expressly spelled out, it's implied, but the committee may wish to consider just spelling that out in that language. Page 6, line 22 provides factors that the commissioner must consider as the commissioner looks to approve or deny an application, including the proposed impact the merger would have on competition for trust company business in Wyoming, whether the proposed merger or acquisition would prejudice the interests of trust company customers, the character and financial status of the parties, whether the merger or acquisition would comply with all applicable laws, and the results of any investigation or examination that may be held under this section. Page 7, line 15 requires that before an application is filed, the plan of merger or the terms and conditions of acquisition must be approved and documented in writing by the shareholders or members or the board of each trust company participating in the merger or acquisition. And approval for that must be sought as required by the governing documents of the trust company or as otherwise provided in the chapter regarding trust companies. Page 8, line 4, this specifies what happens upon approval of a merger or acquisition and once that is consummated. So the former trust company must surrender its charter and if required, dissolve the underlying business entity. If the trust company is chartered in another state, it must follow any procedures that that state outlines in its laws. The resulting trust company assumes the last assets and liability of the former trust company. Moving on to page 9, the resulting trust company becomes a successor trustee, and the resulting trust company may conduct trust company business and other permissible activities as the former company could. The resulting company can use the name of the former company or it can select a new name, but it must notify the commissioner of its intent to do that. Of the name it selects. Any reference to the former trust company shall be considered a reference to the resulting trust company in any sort of writings or documents, so long as it's not inconsistent with our law. And then finally, the resulting trust company must file a certificate of the merger or acquisition with the Secretary of State. Page 10, this provides that a resulting trust company, that successor entity, cannot maintain more than 2 trust company branches in other states after the consummation of a merger or acquisition. Page 10, line 5 just authorizes the commissioner to adopt or promulgate any rules that are necessary for effectuating this section. Moving on to the bottom of page 10, this is amendments to existing statute. And the first change is to the section regarding the State Banking Board. Currently, there are 7 members of the board. On page 10, line 18, we're changing that to 9 members. Of the appointed members, Instead of 4, 5 members must be officers or directors of state, and then also adding or national banks. Currently, 1 is required to be an officer or director of a national bank chartered in Wyoming. That language at the bottom of page 10 is being stricken. Moving to page 11, line 2, language is being inserted to provide that 2 of the 9 members on the state banking board must be officers or directors of public trust companies. And then the remaining changes on lines 5, 6, and 8 are conforming amendments to account for incorporating trust company members on the banking board. Mr. Chairman, moving to page 11, line 19. This amends the definition of trust company to reference a corporation or a limited liability company that's incorporated or organized in this state, or a foreign corporation or limited liability company that is qualified to do business in this state. The words "as a trust company" are being stricken in this bill draft. And the one thing I would note here is that it's not clear whether this change would allow foreign corporations and LLCs to be a trust company just by engaging in trust company business, or if they would still be required to go through the charter process in Wyoming before they could indeed engage in that business. Page 12, line 4, this adds a new subsection to the section regarding insolvent trust companies and receivership. And it provides that if the commissioner determines that it is in the best interest of the state and the supervised trust company, the commissioner can require the supervised trust company to file a bankruptcy as provided under federal law in lieu of a receivership under that section. The staff comment highlights the question of whether there is an issue with this language that essentially allows a government entity to compel a private entity, albeit a regulated one, to pursue specific legal action. Bankruptcy is a creature of federal law. And it's unclear whether a state law can compel a business entity to pursue specific action under federal law. I found no case law regarding the legality of a state law that authorizes the state to compel a business to file a specific lawsuit or seek specific legal action. The one case that I did uncover in my research is that if an entity is governed, this is another state court that held that if an entity is governed by federal law, a state law that requires that entity to complete certain registration requirements before being able to sue in that state can't apply to those entities regulated under federal law. Mr. Chairman, the upshot of this language and this issue is it's not clear how a court would view it if it were to be challenged, but I simply highlight it for the committee's consideration as it considers the bill. Moving on to page 13, line 15, this adds a subsection to the section regarding the formation and organizational instruments for public trust companies to say that that section doesn't apply to foreign corporations or LLCs who are qualified to do business in the state, and that applies for a charter under this article. Page 13, line 20, this adds similar language to the section regarding the organization of a chartered family trust company to say that that section doesn't apply to foreign corporations or LLCs who are qualified to do business in Wyoming and apply for a charter. And then page 14, line 1, this just adds a subsection for requirements for chartered family trust companies to state that the board of directors or managers must hold regular meetings at least once a year. The commissioner can require meetings more frequently of that chartered family trust company, and that company must maintain records of all proceedings that it holds. The bill is effective July 1st, 2021, and with that, I'm happy to answer questions.
Questions, Senator Coe.
Yeah, thank you, Mr. Chairman. I guess I'm curious why we go from 7 to 9 at the state banking board. I don't recall that discussion. Is there a reason why we're doing that?
Mr. Fuller, would you like to pontificate about that?
Mr. Chairman, no, not really. Mr. Chairman, I think that question is best handled by the banking division. You know, I would note that change, I believe they did mention it at the June meeting, and that language was included in the bill draft that they shared with the committee back in June.
I'm curious about that change also. We're having a lot of trouble statewide getting people to serve on boards, and to increase that by 2 just seems to me like and maybe the banking group it's easier to get people to serve on those boards, but I wonder about that. Any other questions about the bill from the LSO?
I do, Mr.
Yes.
Chairman.
Mr.
Yes, Mr. Fuller, I just, and I want to go to your very first staff comment on 3. I tried to follow this because the term resulting trust company is used throughout, and there are several different types of mergers. And one is where you do have the resulting company. And I may have a question or 2 for the commission on this as well, but can you just articulate your concern just a little bit? Because I see that as a proper definition. So just help me.
Yeah, Mr. Chairman, Chairman Greer, the only thing that I was trying to highlight with the staff comment is the question of whether or not a resulting trust company would ever operate under a new charter. Right now, that language on page 2, lines 19 and 20 just says that it's the trust company that will continue operations under an existing charter. And so, you know, if the character of the trust company were to change for some reason, for example, you know, the only question I was trying to raise is whether there would ever be a time where a resulting trust company would operate under a new charter.
Mr. Chairman, okay. And that was on the line of the questions I had for the commission. So they're kind of teed up on that, can answer that. Okay, thank you.
Other questions for Mr. Fuller? Questions for Mr. Fuller? Hearing none, I believe we've got Albert Faulkner teed up for a discussion on this. Could we hear from the commissioner?
Yes, good morning, Mr. Co-Chair and committee members. Albert Faulkner, Banking Commissioner. You'll see on the screen with me, I have our Deputy Commissioner of our non-depositories, Joe Mulberry, and our General Counsel, Chris Land, known to many of you as well. First of all, yeah, thanks, Mr. Fuller, for going through that. You know, my talking points here, I can just discard that now because he did a great job walking you through the bill. So it made my job a lot easier. I appreciate that. But no, he represented it well. So there's a couple things, maybe if it's all right with you, Mr. Chairman, again, since we've walked through the bill, the few questions I heard, if you'd like, I can address that, and then just have one change that we're contemplating. I'll bring that to the attention as well.
Why don't you just go ahead and do that, Mr.
Okay. Thank you, Mr. Chairman. So the question about the state banking board, and that actually is then a possible proposed change. And I think you asked about participation on board. Sometimes is difficult to get participation. Well, my answer to that is that none of those must be as fun as the state banking board, because as you know, we tackle some exciting topics like trust company formation.
Yeah.
But no, this is the idea around this, as we kind of alluded to at the last meeting, was we've had significant growth in the number of chartered trust companies in Wyoming, and for those that are in this space, practitioners, attorneys, accounting firms that represent and do the accounting and audit for trust companies can attest to that Wyoming has propelled itself probably to the top 3 or 4 CITES in the country. And I even touched on last time that the U.S. has become really a top CITES globally for a number of reasons. Assets are flowing back into the U.S. For a while there, they were flowing out to places like Switzerland and you know, the quote unquote Swiss bank account. Well, due to some reporting requirements, that's not as favorable. And then also the world has gotten a lot smaller. A lot of non-U.S. persons now have beneficiaries in the U.S., things of that nature. So there's a number of reasons to bring assets back to the U.S. And so once they do that for the international business, they're also looking at, well, what jurisdiction is most favorable. And this committee and the legislature as a whole has maintained a very modern and inviting trust code in the state. And so that helps, our tax structure helps, and then some of the things that we do within Title 13, Chapter 5. So I say all of that to set the stage is we have currently 30 banks that are domiciled in Wyoming. 25 of those are state chartered and 5 of them are a federal charter. 3 are national banks and 2 are federal thrifts. And the banking board has always been comprised of, as you can see prior to proposed amendments, banking representatives and a couple members of the citizenry at large. Up until just a week or two ago, when we had our first SPDR charter hearing, we had not had a de novo bank charter in Wyoming for the last 14 years. But in those 14 years, we've chartered 15 trust companies. So we now have currently 17 trust companies that have a Wyoming charter. We actually have 2 more in application status in our office right now. And there's always rumors of 1 or 2 looming out there. So we very well could end the year with 19 or 20 trust companies. The public trust company charter does require a hearing before the state banking board. And so we thought that now is probably appropriate to expand the board to include a representative from that sector, the financial services sector in the state, given the activity in that, and it's a sort of a resident expert, if you will. Now we've talked to, and maybe I should back up, we've reached out to the Wyoming Bankers Association, we've reached out to the Wyoming Trust Association about this, we've talked to the banking board, and we've not had any real objections. The Trust Company Association is in support of this. I don't think they have anyone today, but they wanted us to pass along that information. The discussion though is do we expand the board by 2 or by 1? And we use 2 sort of as a placeholder. We can argue either way. I think having heard some comments back from the Banking Association, they would prefer we just expand the board by 1 at this time, have 1 trust company representative. I'm fine with that. Like I said, the Trust Association has no concerns with that. So I would propose maybe changing that from 2 to 1, and that 1 individual, be from a public trust company. So there's that part, and we'll let the committee think about that. The other question I think Co-Chairman Greer asked about, and this goes back to the resulting trust company question and to the staff comment. Definitely appreciate the comment to think about, but to Mr. Fuller's question, there would not be a time where you would have a new charter as a result of a merger. They would be, the way this law is contemplating is merging into an existing Wyoming company. Obviously, if they're merging out of the state, then our law no longer applies. They become they surrender the Wyoming charter and they become under the whatever state they're operating in. The brief history on the proposal of this section, which is obviously the meat of this section, is we actually have this issue pending right now in Wyoming. The first time we had to contemplate it, we have an existing chartered trust company that is looking to potentially merge with I see only one. Mr. Chairman, I see the Senator Rothfuss's comments are you all hearing me okay?
Mm-hmm.
Okay. So it must be Senator Rothfuss, your Wi-Fi on the back deck, maybe not as good as okay. Sorry about that. So we actually have an issue where a company is looking at acquiring and merging it into their existing Wyoming company, an out-of-state trust company. And as we talked with legal counsel for that company, we realized there was nothing guiding how that would happen. So that's where we looked at this. We looked at the state of South Dakota, which I think most of us know has a very well evolved trust company structure. They've probably got one of the largest regimes in the country. And so their laws are pretty well established. We looked at our existing bank merger language, and so we kind of incorporated that into this language. And that's so the text here regarding the merger acquisition that's kind of the basis for it. And like I said, it's a very real time scenario that we're facing, and we're looking for some guidance from the legislature on this, and putting forward some procedures that we can all follow. So with that, I think those are most of the questions, Mr. Chairman, other than I think we had one other legal portion that I wanted to hand over to Mr. Land to explain a little bit regarding a question that was asked or pointed out. So maybe first of all, I'll stop though, Mr. Chairman, if there's any questions on those issues.
Mr. Chairman? Mr. Chairman, you're on mute.
Representative Furphy.
Thank you, Mr. Chairman. Let me ask about on page 12 of the document about potentially filing for bankruptcy. I'm just curious what your thinking was behind that. And so I'd appreciate that. Thank you.
Mr. Chairman, Representative Furphy, that was actually the issue that I was going to tee up for our general counsel to discuss. So if that's okay, I will turn it over to him for some explanation and background and thinking behind that.
Mr. Chairman, thank you, Commissioner. With the committee's indulgence, there's a potentially serious issue that's lurking in the background of our trust company structures. We have a really comprehensive scheme of trust company regulation in Wyoming, but were a trust company to fail, we would be in a particularly sticky situation for two reasons. One is there's not a lot of legal clarity around how the receivership would go and the interplay with federal law. And the second issue is the cost to the state. In the case of banks, we have the FDIC to act as receiver and pay for the cost of resolution. In the case of the SPDI, we have their pledged capital. But trust companies are only required to pledge a relatively low amount, and it would not likely cover the division's expenses for receivership. So, that's one of the things that I urge the committee members to kind of, think about moving forward is, how we can protect the state and the cost of a receivership. But on Representative Furphy, to your specific question and to the staff comment, this is an attempt to bring more legal clarity to our respective powers and roles if a trust company were to fail. Currently, trust companies are subject to the U.S. Bankruptcy Code, and there's a good amount of case law to that point. But at the same time, Wyoming law doesn't contemplate that we would not be the receiver. Under state law currently, we have to take possession of the trust company. Theoretically, someone could, a trust company could always decide to go around us and file for bankruptcy in the federal bankruptcy court here in the District of Wyoming. But, we would still be mandated under state law to take possession. So our respective roles aren't clear. So that's what this amendment is tried to address, is that if the receivership's going to be too expensive, or it's inappropriate, or it would be we wouldn't have the resources to execute the receivership, we have the ability to direct them to submit themselves to federal bankruptcy court jurisdiction as authorized under federal law. As council's noted, there's not any precedent on this issue one way or another. It's not clear. It would be an issue of first impression probably in the in federal bankruptcy law. But some things to note is we're not modifying the substance of federal bankruptcy law because trust companies are already subject to the bankruptcy code, and the trust company charter is a creature of state law, so it's not a creature of federal law. So we have a bit more wiggle room potentially. But you know, the whole point of this provision is just to potentially save the state time and money on a failed trust company. And I'll leave you with one other nugget. There's a trust company receivership in Illinois that's been going on for 10 years, and it's 15 years, I'm sorry, and has cost the state of Illinois about $17 million in receivership costs. And that trust company, currently in Wyoming, trust companies only have to pledge $1 million. So there would be potential for a significant expense were we to have to wind down a trust company. Thank you, Mr. Chairman.
Any questions for the Forkner Group? Any questions? Yes.
Mr. Chairman?
Greer.
Yeah, thank you. I actually have a couple questions, but let's talk about this issue of on page 12 that Representative Furphy brought up. And I believe I'm accurate on this, but will stand corrected if I'm not. But a receiver can take the entity into bankruptcy. And I'm pretty sure that's correct. And if I'm wrong, somebody correct me. But here's the issue I've got. So we create a CITUS, or a forum for trusts, that's supervised and regulated. And then we say, well, if it goes wrong, we don't want to act and act as the regulator and deal with that bad situation. I know that's not the case. I'm not pointing fingers at the commission. I'm just saying you're trying to save money. But here's the simple fact is that I have a little bit of difficulty with that. I think that that there's a bigger policy issue here. And that issue is that the commission, if we are going to receive the funds for this, we're going to manage it, we're going to supervise it, we're going to regulate it, that means we do it in good times and bad. Yeah. And that we should have to take that into receivership. And if the proper course of action is that receivership files a bankruptcy, because I agree with Mr. Land that, yeah, there are a lot clearer rules and a lot quicker resolution in bankruptcy court than there is trying to work through a receivership in Wyoming. I'd like to know, Commissioner Forkner, your thoughts or your comments on that observation and question.
Mr. Chairman, Mr. Co-Chair, yeah, absolutely. Those are very appropriate questions, and yeah, the thought is, as Mr. Land said, there just really is no clarity. And is this an option that would be potentially an effective and efficient means of a wind down of a failed trust company? Maybe it is, maybe it isn't. Again, we would think that this would establish a little bit more of a legal certainty, but we fully recognize that there might be other issues. And to your point of, yeah, we can't just regulate, take in supervisory fees, and then walk away if something implodes. But continuing to find ways of protecting, the Division of Banking, Department of Audit, State of Wyoming, and one goes down because it is extremely costly. And so this was one area that we contemplated of a possibility that might be an additional protection to the state. Now, all that said, hopefully we're never faced with this, that's my goal is to never have that issue. But that's the thinking behind it. Leave it up to this committee to decide if that's appropriate this time. We just wanted to raise that as a possible solution, to have that in the quote unquote tool and toolbox if needed.
Mr. Chairman, just briefly, yeah, like the commissioner just said, it's another tool in our toolbox. But at the same time, though, we're definitely open to, finding other potential ways to protect the state in the case of a trust company receivership. It's mainly around money and creating some kind of, financial backstop to cover our resolution costs. This is definitely not the only way to do this, but until we have a sufficient amount of resources available, it's an important tool.
And I might add just a little bit of background if I could, Mr. Chairman. So the committee might remember we do have we established a trust company resolution fund a few years ago. We had some reserve monies that we put in there. So we have $1 million that we put into that fund. And then a quarter of the annual assessment that trust companies pay goes into that. Now, the issue is the annual assessment is $7,500, and it's just a flat fee. It's not based on assets under management. And that there's a longer story as to how we came with that. But so 17 companies, 25% of $7,500. We're not adding a whole lot per year. I don't even know if we're up to 1.1 million at this point. And I can't imagine any scenario where a failed trust company would cost less than that. And so that was one of the issues. We just don't have enough, whereas South Dakota has a significant number of companies that they could actually do a special assessment on those to cover potential costs. They have the ability, they've got a captive insurance stood up for the state of Wyoming, or state of South Dakota as a backstop as well. We don't have some of those, but with the growth in the industry, we were, again, just exploring options of protecting the state.
Other questions for the Forkner Group?
Yeah, I'm sorry, Mr. Chairman, I did. And, you know, I'm not particularly opposed to this idea. The concept of getting reserves built up and working with a captive insurance group is intriguing and something maybe to keep on the radar. Here, I have a more general question, and so I'm missing this somewhere. So, you know, a public trust company gives services to the general public by definition. It's a supervised trust company. And so when I look at page 8, it starts at page 8, Romanet 3, and then over to page 9, we talk about, unless specified in the customer contract, that those assets will roll over to the resulting trust company. Where is, or is it necessary that, and I think most companies would do this, but a notice to the customers of the merger?
That's it. Yeah. That's it.
Mr. Forkner, do you want to address that?
Yeah, Mr. Co-Chairman, Co-Chair Greer. Yeah, and I'm going to assume, which we know sometimes that's not a safe thing to do, but most governing documents of the corporations would talk about that. That might be something we need to contemplate to see if we need to add that language. I think that would be a pretty easy amendment, you know, just given notice. If you think about it today, banks can sell and merge customers. I'll have to go back and see what kind of notification customers are required. Obviously, it's the shareholders that are the ones that are impacted. As long as your account doesn't change in the new company, the customer shouldn't be impacted. But I'll look to see what other language is out there on that, and to see if we need to bring that as a potential amendment.
Yeah, and Mr. Chairman, I don't think we need to worry about that today. We can maybe look at that as this bill, if this bill works through the process. But I think customers are sensitive if the resulting company is one that doesn't support our troops. I may not want my assets with them, right?
Absolutely.
Yeah.
Mr. Forkner, as you're saying you're trying to build up a fund to defend the state, and it's $7,500 per title company. Why wouldn't we have them post a bond? Is there a way to have them post a bond instead of trying to depend on their fees?
Mr. Chairman, they have to do one of two things. They have to pledge their capital or post a bond. I think universally it's been a capital pledge because the bond is just too expensive to maintain. It's easier to have a irrevocable pledge, but you got to remember the trust companies, depending upon the business plan and operations, capital levels are roughly $1 million. You know, they go up a little bit from there, but it's not near. Trust companies just don't have near the capital requirements that banks have for various reasons. But so you potentially have, let's say a company has $1 million pledged to the state of Wyoming, assuming that capital hasn't somehow been eroded fraudulently. We would have that, and then the $1 million of the resolution account. You use that $2 million let's say it covers the cost and there's no out of pocket, that's great. But then we also have then the problem of reestablishing that resolution account. And how do we do that with the resulting companies? So that would be a question, that's maybe a question down the road to contemplate. Again, hopefully we never have to be faced with that. But that's how the structure currently is.
Any other questions for the Forkner Group? Other questions? If not, thank you, Forkner Group, for your input. We appreciate it. Look forward to working with you more. We have another banker here. I think Mr. Meyer might like to speak to us about this issue. Mr. Landis, are you, or Mr. Meyer, are you up?
I'm here, Mr. Chairman. Members of the committee, Scott Meyer, President and CEO of the Wyoming Bankers Association. I will say that I had an opportunity to meet with Commissioner Forkner and his staff, both of which are included with him today. We did have a chance to discuss this. I will tell you that we're completely in support of the commissioner on this. We did raise the question of whether, kind of based a little bit on what Chairman Anderson had said about board members and trying to get those people to be involved. I really haven't had too much trouble, I don't think, with respect to banks being on the board, but the idea was that maybe we would increase it only by one. I do think that Commissioner Forkner does have to have somebody that has they have to have a little bit more focus on the trust company side, and so that makes a lot of sense to me. If in fact we just increased it by one, you would have an even number of board members, but I guess that would mean that in the unlikely event that the board were split, then I guess it would not pass because it would be deadlocked. But I have yet to see anything with respect to the state banking board come across that situation. So I think that in the idea of maybe saving costs and trying to make sure we have the right people on there, that maybe increasing it by only one is appropriate. I will just throw out just briefly, if I can take off my banking hat and put on my law hat, that I do think that Mr. Fuller's comments regarding, respect to federal law and state law, I think he's probably right on point. But I do believe Chairman Greer brought these things up, and I think that there's no use belaboring, although I will add that, yes, a receiver can apply for bankruptcy. So with that, I would stand for any questions.
Any questions for Mr. Meyer? Any questions for Mr. Meyer? That looks like a question, Representative Furphy. No?
Mr. Chairman?
Yes.
This is Albert Forkner. I just wanted one thing that just for the committees I failed to mention. So the State Banking Board, yeah, there are currently 7 appointed members from the governor, but the director of the Department of Audit serves as a ex officio member. So, and it's a voting ex officio member. So to Mr. Meyer's point, so technically with one person, you would have an odd number board. Actually 2 would make it 10. So I just wanted to bring that to attention. So I think even the issue of a tie vote was maybe rectified with the structure of adding just one.
Mr. Forkner, does the ex officio vote? Usually they don't vote.
Mr. Chairman, yeah, this one, there's not a prohibition to voting. And so the director has the ability to vote.
Oh, okay. Any other questions for Mr. Meyer? Any other questions for Mr. Meyer? Okay, Mr. Meyer, thank you very much for your testimony again today.
Thank you, Mr. Chairman.
We'll look forward to seeing you soon. Okay, any other public comment? I see we had one in the waiting room. Does he want to talk on this?
Mr. Chairman, I believe Mr. Obermuller will be speaking later on a different topic.
Okay, all right. All right, we'll close public comment. And committee, what's your pleasure? Mr. Furphy.
Move the bill, Mr. Chairman.
Furphy moves it and Rothfuss seconds it. It's been moved and seconded. Representative Furphy.
Yes, thank you, Mr. Chairman. I do want to report, as Chairman Greer asked me to do, I provided this information to the Wyoming Trust Association, Bob Leonard, who's the head of that, and they are in favor of this bill. So I just wanted to point that out. So thank you.
Thank you. Any other comments on this motion? Any other comments? Do we want to work the bill, or do you know what you want to change? Or do you want to change anything? Well, we'll go through the bill real quick then. Any changes to page 1, any changes to page 2, changes to page 3, changes to page 4, change to page 5, changes to page 6, change to page 7, page 8, page 9, page 10, page 10. Is there any changes to page 10? Senator Coe.
Yeah, thank you, Mr. Chairman. I would move, just for discussion, that we delete 9 and go back to 7 on page 10 and open that up for discussion. I would make that motion.
Moved and seconded by Henderson. Moved and seconded. Okay. Would you like to discuss your motion? Your amendment?
Well, Mr. Chairman, I think that your discussion was pretty good as well, but I guess I'm just not totally convinced that with the conforming language on page 10 and 11, that we can't go back to 7. That's it. My thoughts, Mr. Chairman. I just bring that for discussion. I wonder why we actually need to go to 9 rather than 7.
Any other discussion? Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, I could be compelled to go to 8, but I think 7, when you want to add a new trust expert effectively as the objective, or one of the objectives that's being laid out here, we would have to wait until there's a transition or a change in the board as it stands right now to really effectuate some of the objectives that they're seeking. We also know, first of all, that this is not a general fund expense, to my understanding, and I guess if somebody disagrees with that, please correct me. But typically, everything that's division of banking and banking related ends up being paid for by their own internal fees that are assessed to the banks. And if the banks are actually requesting that it be moved up to 8, I'm fine with that if they feel that they're better governed that way. So it's not a general fund issue for us. It's not a budget issue. They do an excellent job. They have a lot of work. I don't know if anyone took the opportunity to watch the application by Kraken for Special Purpose Depository Institution the other day. It was real testament, though, I think, to the exceptional and work that they do and the hard work that they actually get done. So again, if they feel that 8 is appropriate, which is kind of what I heard, I didn't hear a lot of advocacy for 9, but I heard advocacy for 8. Then I would resist this motion, but I would support a motion to amend it to 8, and then the corresponding conforming amendments. I would support that as well. So I'll resist this motion, Mr. Chairman.
Fuller, you had a comment on this amendment?
Yeah, Mr. Chairman, just to note that depending on how this amendment goes, there would need to be at least one other change to decide what 2 members are taken out. Because if you just change 9 back to 7, the math won't add up.
Okay. Any other comments on the amendment?
Mr. Chairman?
Yes, Mr. Co-Chairman.
Yeah, so, and boy, I hate to do this to Senator Coe, but I'm going to resist the motion because I feel like Senator Rothfuss, that we should change that to 8, which would then require the numbers, but one of them should be an officer or director of a public trust company. We've been working in Wyoming, and if you look back over the years, we've done a lot of work in minerals, cleaning up our trust statutes, creating new areas of opportunity. This is part of our economic diversity. I've brought a lot of bills to the legislature, getting a lot of our code to be that top tier. And I think we're starting to see the benefit of that. You heard the testimony of so many trust companies are now siting in Wyoming. And it's a good sector. It's a small sector, but it's still something in the part of economic diversity. And as we do this, I think it's important that we ensure that this sector, the trust sector, has a voice on that board. So Senator Coe, I would love to support you on everything, you know that, but I would like to see at least one person added to this, and that they be directed from a trust company.
Any other comments on this amendment? The amendment is to strike 9 and make it and leave it like it was.
Yeah, Mr. Chairman.
Senator Coe.
Yeah, Mr. Chairman, I would withdraw my motion if the second's agreeable to that. You know, you can't lose all your motions in one day unless you lose the first one.
Is the second agreeable?
Yes, Mr. Chairman, and if I may, I'd move to change it to 8. If I get a second.
So, and Coe seconds that motion to change that 9 to 8 members. And then you would have, you'd also change page 11 to 1 member should be an officer. Yeah, we'll change all that. Any, yes, Representative Duncan.
So just a quick question. Thank you, Mr. Chairman. Just a quick question. Wouldn't you always want to have an odd number?
Well, we some of us are odd on this committee, but they tell me that there's an ex officio of the votes. So this actually makes it an odd number. When we move it to 8, they actually have 9. But I'm not going to get into who is odd, but yeah. Senator Rothfuss. Unmute it. Yeah.
My apologies. Thank you, Mr. Chairman. And I'm going to support this motion, but I do think there's one other number to take a look at. And I think mathematically it can go either way, but that is the page 10, line 20. When changing it to 9, we take that number from 4 to 5 as the number of officers or directors of state or national banks domiciled in Wyoming. And then later we talk about 2 members shall be officers. We from trusts, we take that down to 1. But then there are on line 4, and 2 members shall be residents of Wyoming who are not officers, directors, or employees or public trusts. So if we now need that to all add up, I guess the question is, do we still want to increase the 4 to 5, which would be, I believe, as we see it, 5 plus 2, or excuse me, 5 plus 1 plus 2, which is fine at 8. Or the alternative would be to leave it at 4 and have an additional member of trust instead, since you have the alternative between national banks and state chartered banks available. And that's just a point of consideration. Honestly, I don't care which way it goes. I don't know if there's anybody out there who does, because it's not something we've really talked about or at least I haven't heard any testimony on whether we would want the 5-1-2 or the 4-2-2 approach. Maybe nobody cares, but I'd be interested to see if anyone had any thoughts.
Any thoughts on Senator Rothfuss' thoughts
Mr. Chairman?
in the backyard there? Representative Greer.
I think the 5-1-2 approach, that is this make sure there is one from the trust companies on there. And, you know, if in 5 or 10 years we see 5,000 trust companies located in Wyoming, it would be time to revisit this. But that's what I would suggest, is make sure that they're, instead of, so on page 11, line 2, instead of 2 members, have that be 1 member, and then the math would work. And I would propose as amendment to the amendment.
That's part of the amendment. We added that to the amendment on 8. We added line 2 would be 1 member.
Yep, that's as I understand it too. Thank you, Mr. Chairman. I just wanted to make sure that we had that discussion, and I'm certainly not averse to that approach.
Okay, all right. Any other discussion on the amendment? Other discussion on the amendment? Okay, the amendment is that we change on page 10, line 18, from 9 to 8 members who shall be appointed. We eliminate 7 entirely. We go to page 11 on line 2, we change 2 to 1 and the numerical 1. And then member becomes members, or members become member. All in favor, raise your hand, please.
Mr. Chairman, there's
Yeah.
more, sorry, Mr. Chairman, I don't mean to interrupt the vote, but there's actually more conforming language. So why don't we just tack on a and conform the language and then
Good.
vote?
Good,
Yeah.
let's do that. And conforming language, yep. All right, let's vote. Everybody in favor? It's unanimous. The amendment passes unanimously. Now, is there any other changes on page 10? No more changes on page 10. Any more changes on page 11? Changes on page 12. Changes on page 13. Changes on page 14. That concludes the bill. Are you ready to vote on the bill?
Question.
It's been moved by Furphy and seconded by Rothfuss that we pass this bill. All in favor of that, signify by saying, or raise your hand.
Mr.
Chairman.
Roll call.
Roll call? Oh my goodness.
Mr. Chairman, this is a roll call vote on 21 LSO 0001, version 5, as amended. Senator Biden.
Aye.
Senator Coe.
Aye.
Senator Rothfuss.
Aye.
Senator Wasserberger.
Aye.
Representative Burkhart.
Aye.
Representative Krink.
Aye.
Representative Duncan.
Aye.
Representative Ayer.
Aye.
Representative Furphy.
Aye.
Representative Henderson.
Aye.
Representative McGuire.
Aye.
Representative O'Hearn.
Aye.
Co-Chairman Greer.
Aye.
Co-Chairman Anderson.
Aye.
That passes, Mr. Chairman.
That bill passes on to the general session, or maybe to the September session, depending on what we do.
Mr. Chairman, I think what we'll do is let Representative O'Hearn manage this bill.
Hey, there you go.
We'll see how we do in session. All right.
And what exactly does that mean?
You'll find out.
Yeah, boy. Boy, have you ever got a friend there, Representative O'Hearn?
Yeah.
Woo.
Been voluntold.
Yeah. Yeah, I ask for volunteers, he appoints. Okay, the next bill before us is the Wyoming Money Transmitter Act amendments. Mr. Fuller, would you lead us out on that one and tell us what we're doing?
Yeah, Mr. Chairman, 21 LSO 2, working draft point 4. This draft amends and repeals certain definitions of the Wyoming Money Transmitters Act. It amends actions and entities who are exempted from the act. It amends fees and bonds and security requirements, and it clarifies application procedures for applying for license. So moving to page 2, line 10. This is just what I believe is just a clarifying change to change that reference to money transmission, which is defined in the Money Transmitters Act and is being amended here. Page 2, line 13, the reference in the definition of money transmission, the reference to stored value is stricken from that definition. Page 3, line 1, in the definition of payment instrument, a sentence is inserted that states that payment instrument means prepaid access as defined by the cited federal regulation, and that for purposes of this act, stored value is equivalent to prepaid access. The staff comment just notes what that definition of prepaid access is. And the question really for the committee with the staff comment is whether it wants to incorporate verbatim that definition in the Money Transmitters Act itself versus just simply referencing a federal regulation that at some point in the future could change. There's also in that, at the bottom of page 3 in that staff comment, just a note that given the use of stored value in this definition of payment instrument, the committee may wish to leave the definition of stored value in the Money Transmitters Act. As I'll cover later, that definition is being repealed here in this draft. On page 4, line 6, just striking a reference to stored value. Page 4, line 14, this would provide that the Money Transmitters Act doesn't apply to a person who's engaged in money transmission business that doesn't meet the definition of a money services business under the cited federal regulation. This was a point that the committee considered quite a bit at its final meeting last year. In 2020, that language would be stricken in this bill draft. The implication being that that definition as it exists, whether it's changed in the future or not, would be applicable to this exemption. Moving on to page 5.
Mr. Chairman. We can't hear you, Mr. Chairman.
Senator Rothfuss.
Thank you, Mr. Chairman. And, you know, we can go the rest of the way through the bill, but I just want to note that I do want to address that discussion on page 4, the Romanet 8, because we did pass legislation specifically on this with regard to a money transmitter exemption last year. So while this is being proposed, there was good reason for having that particular language there. And I'll let Mr. Fuller finish, but let's come back to that.
Mr. Chairman, with that, I'll move to page 5, beginning at line 24. This just provides, the stricken language is just conforming to the change that begins on line 26. And this provides that a bond or security device must be provided with the license application as determined by the applicant. An application without a security device, the commissioner can conditionally approve that pending receipt of the security device. And then it just states that the surety bond or security device must be, and then it tracks with the existing language. Moving to page 6, lines 2 and 3, this just specifies that the security device can be 10,000 or 2.5 times the outstanding payment instruments, whichever is greater. And then we're inserting language to say not to exceed $500,000. I think that's just more of a kind of a streamlining change based on the language that is stricken on page 6, lines 5 and 6. Moving on to page 7, Mr. Chairman, the 2 changes on page 7 simply strike administrator and replace it with commissioner. I could not figure out who who the administrator is for purposes of the act. I think these are just conforming changes to reflect the proper terminology. On page 8, similarly, striking references to administrator and replacing that with commissioner. Moving on to page 9, currently licenses for money transmitters who are licensed under the act, they pay an annual fee up to $2,000 with an additional fee for each delegate, authorized delegate and subdelegate up to a total of $7,000. This would strike that language and just say that the annual fee shall be paid by a licensee as set by rule of commissioner. The staff comment just notes whether the committee should consider clarifying that the rule must be set similar to using the process that boards and commissions would use, which would be fees are established by rule in accordance with the Administrative Procedure Act, And then the second point to that statutory reference is probably more salient in terms of delegating this authority, in that it would limit the amount of the annual fee to an amount that, to the extent practicable, the revenue generated would approximate but wouldn't exceed the direct and indirect cost of administering the Money Transmitters Act. Moving on to page 10, line 13, for examinations, a reference to the indirect costs being paid by the licensee or person subject to examination or investigation is stricken. So that licensee subject to examination after this change would be responsible only for the direct costs of any examination or investigation. And then, Mr. Chairman, page 10, line 16, the definitions of electronic instrument and stored value in the Money Transmitters Act are repealed, and the text of those definitions are in the staff comment on page 10, going into page 11. Finally, page 11, line 11 specifies applicability, that this act applies to all applications filed for the 2022 licensing year and any examinations conducted on or after January 1st, 2022. The staff comment there just notes for clarity whether renewals should be included in that applicability section. And then finally, the bill is effective, would be effective July 1st, 2021. With that, Mr. Chairman, happy to answer any questions.
I've heard a lot of discussion on this stored value. I noticed we've got it in here 3 or 4 times. We're eliminating it. How did that? Why was it in there in the beginning? Or do you know?
Mr. Chairman, are you talking about why stored value was defined in the act?
Yes.
Mr. Chairman, I don't know the full history of that. The division may be able to offer some clarity. You know, I would imagine that stored value can be transmitted electronically, and hence its inclusion, but they may have more background on that and why it's in the draft.
Okay, thank you. Representative Greer, did you have a question?
I did of Mr. Fuller, Mr. Chairman. Mr. Fuller, first of all, great staff comments. Just one I want to get, we talk about statutory construction here, on the stored value definition in your second comment on page 3. So we're deleting store value as a defined term, and I see the reason why. It cleans it up. On page 2, line 13, we're deleting stored value. But your comment, is it then in payment instrument? Is it used there again? I guess what I'm trying to get to is I want to understand your comment there. Could you just explain that a little clearer, of why you made the comment and why we should listen to it?
Yeah, Mr. Chairman, Chairman Greer. First off, it's certainly up to the committee to decide, listening to the comment or not. But the point that I just wanted to flag here is that throughout this bill draft, the references to stored value are being stricken. But then on page 3, line 3, stored value is referenced. And perhaps it's to say, perhaps the intent is just to say that stored value means prepaid access. If that's not the case, though, then I think the question for the committee is, is the committee comfortable with a plain language definition of stored value, which would be how a court interprets it in the absence of a statutory definition, or would the committee want that statutory definition, which is at the end of the draft, page 11, line 5, whether they would want that definition of stored value to remain in the Money Transmitters Act.
Okay, I'm following. Thank you. I think Senator Rothos will be able to answer that for us later.
Any other questions for Mr. Fuller? Any other questions? Okay, all right. Thank you, Mr. Fuller. I'm sure we have some comment on this. I see Mr. Faulkner's group is ready to comment.
Again, thank you, Mr. Chairman, and I'll just make a brief introductory remarks, and then I'll turn it over to our Deputy Commissioner Joe Mulberry to get us down in the weeds a little bit. But yeah, the committee might remember that. So we did have a money transmitter bill that went through last session, as Senator Rothfuss mentioned. A couple of these issues, we'll answer his question / concern on that. When the bill went through last session, the fee structure is something that's been misaligned here in Wyoming for a number of years. We had proposed amending that bill at the time, and then determined, given the nature of where it started in the Senate, that maybe it wasn't appropriate to tackle that at that time. And so we were suggested that we come back in the interim and then for the general session to tackle that. When looking at that, we had a few other cleanup issues. And some of these definitional items that were flagged by Mr. Fuller it seems simple, but you'll find out that there's complexity in simple terms. And so with that, Mr. Chairman, if I will, I'll turn it over to Mr. Mulberry to again get us down in the weeds, and promise that at some point we will all surface from that and be able to see the light of day again at the end of this.
Okay, Mulberry, let's see you do it.
All right, thank you, Mr. Chairman. It seems like that the initial discussion has been about stored value. So I think I will address that issue first to see if I can bring some clarity to the stored value issue. So back when we initially passed the Money Transmitter Act and enacted the act here in Wyoming in 2003, we used a model act that was available to us. In that model act, it used the term stored value. Since that time, the industry continues to evolve, and I think now, back when we initially enacted this act, the majority of money transmission transactions were conducted through what used to be what everybody understood to be money transmission. You go to a Western Union location or one of their authorized delegates, being a convenience store, grocery store, somebody that operates on their behalf as an authorized delegate. And that's the way that the majority of the transactions were done. Now with the advent of online transactions being able to be done, on your mobile device, the industry just continues to evolve. And then there are some federal regulations that apply to this industry as well. So it's not just our state requirements, but the federal regulations are in place. And for whatever reason, they use a different definition. They use prepaid access. And so where our law initially just referenced stored value, then some of the federal regulations from FinCEN use the word prepaid access. But those terms in the industry are kind of used interchangeably. They mean the same thing. And so we have to have discussions with industry members, sometimes, and then attorneys when they're looking for interpretations about whether something that they deem their product to be a prepaid access, whether or not, because our law says stored value, whether it's the same thing. And they are, and that's the way that we administer it. So we're proposing to make these changes to just hopefully bring some clarity to that, to essentially put into our law that and right now our law doesn't reference prepaid access. So we're trying to get the terms prepaid access into our law, and then to put in our law that stored value is equivalent to prepaid access, because we like the federal definition of prepaid access better than our current definition of stored value. So, and we had that discussion internally when we were discussing what we were going to propose here. So one of the things that we did consider was leaving our stored value definition in our act. But then what we would have done would we'd be recommending that we're amending that definition to mirror what the federal FinCEN definition that's cited here for prepaid access. So if we're going to leave the stored value definition in our act, then we would like to amend that definition to just be the same language as prepaid access.
Mr. Mulberry, we have a question.
Yes.
We have a question. Senator Rothfuss.
Thank you, Mr. Chairman. Joe, on this point, I mean, it seems like there's a few ways to do it. Usually we're quite sensitive, and we'll have the other concern we'll talk about in a little bit, to just citing to a federal statute recognizing that it could change, and we wouldn't necessarily want our state statute to change. Sometimes that matters quite a bit. We know with the Money Transmitter Act, we have flexibility in a lot of ways. You know, Montana doesn't even have a Money Transmitters Act. We've had that discussion before, but we're keeping ours and complying. So why not, instead of citing this, or alternatively going with stored value with a different definition, why not switch our term in this legislation to either payment instrument or prepaid access, and then use that definition and then do a substitution for stored value throughout, so that we are compliant with FinCEN, but at the same time, we're relying on state statute definitions instead of federal definitions?
Mr. Chairman, good question, and those are definitely things that we considered when we were considering our proposal. You know, one of the issues, another issue that you kind of touched upon, is that it does create confusion, like in the definition of money transmission, when it says money transmission means to engage in the business or sell payment instruments / stored value. So by definition, a stored value product is a payment instrument. And again, that's another one of the confusing issues. By having it be separate, like in that manner, then we have to continue to have those discussions with people that in fact a stored value product is a prepaid or is a payment instrument. And so, you know, that by putting it all into the definition of payment instrument, hopefully that'll bring some clarity. By just going with prepaid access, because we considered that as well. But again, in the industry, the terms are used interchangeably. Both terms are kind of used within the industry. Now, the FinCEN definition says prepaid access. And so, but in the industry, in the discussions that we have, some people call their products stored value products. And again, they're kind of, the terms are kind of used interchangeably. So I think we're trying to to develop a definition here that makes it clear that both of those terms are identical, and and this is what they mean. So, you know, we're saying that this is what they mean by referencing to the federal definition that we like, and then we would choose to use if we're going to bring the definition back into our act for stored value. Then the alternative would be, then I think if we're not going to reference to the federal regulation, then we would have to use some of the same language, and then to use that payment instruments includes prepaid access. Then we would need to add a prepaid access definition into this act. And so, which would be the exact same definition. So we would have definition of prepaid access, definition of stored value, and they would both within our act copy the language that's in the federal FinCEN definition. Now, you know, as to the issue of citing to, and I understand, you know, this gets to the other point that we're going to talk about it as well, about just citing to federal regulation. I think we feel like it makes sense here because all of the companies that operate here in Wyoming are national companies. There's no licensee that we have under the Money Transmitter Act that only operates here in Wyoming. So if we were to have a different definition than what happens on the national level because of the federal regulations, we would be creating a situation where if there was a change to the federal definition, then we would either have to make that come back and make that corresponding change into our act, or we would have a situation where the companies that are licensed with us have to operate they're operating under the federal regulation in all the other states that they're doing business with, but then they have to do something specifically for Wyoming. And we kind of see that as a potential burden. And I think we would, you know, obviously we don't know what changes are coming about, if any were to come about on the federal level. The only time that a change that we would be required to do something, then if a change were to occur in the federal definition, and for whatever reason we just didn't agree with that change, but then we would have to go back in and change it. But if we put the definitions in our act, and a change is made, even if we agree with it, to say, oh yeah, okay, you know, that's what we're going to do here in Wyoming. By having it in our act, that necessitates that we come back to you folks and to say, you know, hey, we need to make changes to these two definitions for the reason that the federal act changed. So by linking it to the federal regulation and knowing that for the most part, we are going to maintain consistency with that regulation, we feel like it's probably the most efficient manner to do what we proposed.
Mr. Mulberry, you certainly got in the weeds, and now we can get out of the weeds. That was all the discussion on stored value.
Mr. Chairman, just a real quick follow-up, and I do appreciate that, but I will say that the idea that it's a problem for them to come to us with legislation on the Money Transmitters Act seems to defy the entire experience I've had in the legislature, where I've carried a Money Transmitter Act bill, I think each and every session. So it seemed like a high bar.
I just got done working out, and
I'm sorry they weren't referring to your actions. Senator Rothfuss. Any other discussion with the Forkner Group? Anything else for the Forkner Group? Okay, we're going to move right on to Mr. Meyer.
Mr. Chairman, I don't think they were done yet. I derailed them. I think they probably have more, maybe not. But I do have more questions. I just thought they were going on.
Right. Mr. Chairman, I guess if there's no other discussion about the stored value portion, then yeah, I will move on to some of the other sections. I think Mr. Fuller did a good job of explaining what some of our proposed amendments are. I think, you know, the main amendment that we're bringing forward, as Commissioner Forkner said, is what we contemplated last year, and we're still bringing it forward. It's a change to our structure of our annual license renewal fees that are assessed to companies and the methodology of that assessment. And so currently all licensees pay an annual renewal fee to our office of $1,000 plus licensees that engage in business by offering their services through those authorized delegates that I mentioned must pay an additional fee of $50 per authorized delegate location, up to a maximum amount of $6,000. But like I said, with the advent of more and more transactions being able to be completed online or through mobile devices, a number of our licensees that engage in the largest volume of business in Wyoming, they do so without the use of those authorized delegate locations. So as a result, some of our largest companies that require most of our regulatory time and efforts only pay an annual renewal fee to us of $1,000. Where some of the smaller companies that do less volume, but they may do so through the authorized delegate system, they have to pay an annual renewal fee to our office of $6,000. And so we're just trying to address that situation, and we're proposing that we enact some kind of a structure. We're looking so that we can put in place by rule an annual assessment that more aptly sets the annual assessment to the companies that do the majority of volume here in Wyoming under the act that require most of the regulatory efforts. And so that's why we're proposing this change. This change has been, you know, there's other states that regulate money transmission that do the assessment in this manner. And it seems like, you know, more and more with the advent of, like I said, you know, this industry continues to evolve. And I think that, you know, we all now have the capability of sending money on our smartphones, where, you know, just a number of years ago, we didn't even have that capability. So we're just trying to match the evolution of this industry and then the people that are operating in the industry, and try to be a little bit you know, more fair and look at maybe being doing the assessment more to the larger companies, and hopefully giving a break to some of the smaller entities that operate under this act. So that's dealing with the annual assessment. So I'll take any questions that we have on that issue.
Mr. Mulberry, what page are you referring to on the annual payment? Is that 5 or 6?
Mr. Chairman, that starts on right at the bottom of page 8 is the heading, but then the actual language is on page 9.
Oh, okay.
address the staff comment.
And all you're saying is you're going to eliminate that language. You're not, and you're setting the rule by the commissioner. Huh?
Mr. Chairman, that's correct. And this kind of matches, you know, we have a number of laws under our jurisdiction. We have the Wyoming Uniform Consumer Credit Code, the Wyoming Residential Mortgage Practices Act, the Rent to Own Act, or the Rental Purchase Agreement Act. In all of those acts, our licensing fees are, we set all of our licensing and renewal fees you know, by rule. And so that's what we're looking for here, is just to take out the actual dollar amounts that are put in the statute, and then to allow us to do it by rule. But then, we've been working with a number of methodologies that we would enact. And I think that we've found a methodology that just kind of, again, changes around, you know, so that the larger companies are paying the largest portion of the annual assessments, and that's the funds that we use for our regulatory efforts of this industry. It would actually, under the proposals that we're considering, give a break where the minimum fee right now is $1,000. And there's some companies that hold a license, but they actually do 0 transactions under that act, or under that license. So we're looking to possibly lower the minimum down from $1,000 to $500. So giving a break to some of the smaller companies, but again, charging the larger companies the largest assessment.
Okay, any questions for the Forkner Group, or do you have another issue you're going to talk about?
Mr. Chairman, I guess I was just going to address the staff comment, and so yeah, I know Representative Greer has a comment. So would you like, or a question? I can either take his comment or I can address the staff comment.
You go. Yeah.
Okay.
Go ahead.
Thanks, Mr. Chairman. So regarding the staff comment, I guess, you know, we look at it, and that section, this act isn't under Title 33 or Title 23. And so I don't think that applies.
What page are you on staff comments? There's lots of staff comments.
Staff comment on page 9.
Page 9, okay.
Yeah. So, you know, I don't think that section applies to us. And so, and again, you know, Mr. Chairman, I think that the way that we do all of our licensing, where we are establishing this, you know, so we're following the intent of that in everything that we do. Yeah, we're establishing, you know, our licensing fees, and even with what we're proposing by reorganizing and changing the annual assessment of what we're considering, we are being mindful and trying to come up with a system that most, you know, that equates to what we're currently collecting, you know, from the industry under our current statutory license renewal process here. So I guess that, Mr. Chairman, that's just our comments on the staff. On the staff comment, that we don't believe that that's applies to us, but you know, the intent of that, we understand the intent of that, and it's something that we follow in all of the acts that we administer and set our fees by rule.
Okay. Representative Greer.
Yeah, thank you, Mr. Chairman. But surely you do believe the legislature should regulate your agency, oversee, set policy, right?
Mr. Chairman, absolutely.
Yeah, okay. So, you know, with that, and I've always been uncomfortable with these types of fee structures. And so I like the comments that are there. And I guess my question is when you do your rulemaking, do you follow the rules of the Wyoming Administrative Procedures Act?
Mr. Chairman, yeah, we don't have rulemaking authority outside the APA.
Yeah, and then the next question with that is your fees are there to set to cover your operating expenses. That's correct. I mean, basically the cost of each program that you do, right?
Yes, Mr. Chairman, to do otherwise would be probably arbitrary and capricious from an administrative law perspective.
Yep. And so then, Mr. Chairman, and then again, you take all of those, but basically where you report is to appropriations each year. When you submit your budget, you break down by section, by division, what revenues are in and then what costs are associated with that. And that's the primary reporting component with respect to fees, if I understand that correctly.
Correct. Yes, Mr. Chairman. Yes, Representative Greer.
Then, Mr. Chairman, I have one more question, and I just, with respect, shall apply to all applications for the, so it's a 22 licensing year and examinations. Do we need to say all applications and renewals filed for the 2022 licensing year? Is that appropriate?
It's a renewal application.
Yeah.
Oh, yes. Let's just answer.
Mr. Chairman, yes, we would be fine with that. And I think that the appropriate thing would be to say that this act shall apply to all renewal applications filed for the 22.
Applications, renewal applications, and.
Okay, all right. I just want to make sure we get it right. Thank you, Mr. Chairman.
Other questions? Senator Rothfuss.
Thank you, Mr. Chairman. I did want to go back to page 4 and have a separate discussion about line 14, which relates to the FinCEN small operator exemption and the reference to federal regulations there. Now, this was an instance where when we drafted this legislation for the Money Transmitter Act exemption for small operators, and you see in the staff comment, everybody that's following along details of what that exemption is. So if you're a small money transmitter operator, then FinCEN, the federal statute, provides you with an exemption. We did not have that exemption in statute, so last legislative session, we basically mirrored that statute. The blockchain task force decided that in this instance, it would be important to have a date certain of which statute was in place, because these small operators would not be frequently checking the statute. And to the extent that it's an exemption, not a license requirement, we would not want to have a change in the Federal Register represent something which could then cause problems, because under Wyoming statute, a small operator would suddenly find themselves requiring a license when yesterday they didn't require a license. And since they're a small operator, they don't have the legal team to go in and check for that. So I see that line 14 has that date certain struck. So I want to know if the logic and reasoning has changed since we included that language, or why we would want to hold these exempt entities all of a sudden responsible for checking with changes to the Federal Register every couple of weeks to make sure that they're not violating statute.
Mr. Chairman.
Workner Group, would you like to address that?
Yeah, Mr. Chairman, thanks, Chris Land, General Counsel, Division of Banking. This goes to Mr. Mulberry's comments earlier, and I was the primary impetus of this particular change. We don't have any licensees in Wyoming currently, and we're trying to reduce the burden for all these companies as much as possible. And it's more of a burden in our perspective for them to have to, comply with two versions of the law, Wyoming law and federal law, while at the same time, trying to run a business. So, our thought is reducing the burden is probably best achieved by having our law conform to federal law as closely as possible, even when it's updated, so we don't have to run another bill. That being said, this is kind of more form over substance. It's a form over substance thing, and it's not a big issue, but that's kind of our best view of, in a perfect world, this is how it would be, but we recognize that there are other considerations potentially.
Follow up, Mr. Chairman.
Yes.
Well, I see that analysis for the first discussion we had, where you are a licensee, so you have a license, and then you're obligated to continue to follow the requirements of that license, which makes a lot of sense. At that point, you'll be checking what the requirements of that license are. You'll be renewing. You have an active engagement. I don't understand how that line of reasoning, and particularly from a simplicity standpoint, to decrease how onerous it is. When you are a business that's operating under an exemption, it seems that the argument goes exactly the other way, which is if I'm exempt today, I don't want to have to keep checking to see whether I'm still exempt under federal law on a day-to-day basis. And there should have to be some change to Wyoming statute to bring about a change in my exemption status. So am I missing the point that you're making, or I mean, do you see the dichotomy there that it doesn't seem to me to be the same thing?
Mr. Chairman, Senator Rothfuss, yeah, we can definitely see both points of view, and I think it's probably best if we just omit that particular change to the statute that's proposed there on page 4, line 14.
Great, thank you.
Any other questions for the Faulkner Group? Other questions, other questions? Okay, let's move on to Mr. Meyer then, please.
Good morning, Mr. Chairman, members of the committee. Scott Meyer with the Wyoming Bankers Association. I will tell you that just as in the prior discussion regarding the bill, just prior to this, that I had an opportunity to meet with Commissioner Faulkner and his staff. We've gone over this bill. We find nothing in there that is objectionable, and therefore we support the commissioner's position on this bill.
Questions for Mr. Meyer? Questions for Mr. Meyer? Hearing none, thank you, Mr. Meyer, for your testimony. Is there any other public comment? Any other public comment? There's two waiting, but I think they're talking on something else, aren't they, Mary Beth?
Mr. Chairman, that is correct.
Yep. Okay, we'll close public comment. Committee, what's your pleasure? Senator Rothfuss. Senator Rothfuss, you're muted. We like what you're saying, but we can't hear you.
There we go. It was a little glitch. Mr. Chairman, I move the legislation.
Is there a second? Is there a second? Seconded by Code. Okay, any discussion on the motion? Mr. Senator Rothfuss, would you like to tell us why we should do this?
Mr. Chairman, I think a lot of this is simply updates, conformance, and trying to bring us in line with, or more in line with federal statute and provide uniformity for a national market. One of the challenges that wasn't mentioned with the Wyoming Money Transmitters Act and All Transmitters Acts is this is a challenge because each state has individual acts. You have to have a license in every state you operate. So you have these money transmitters that end up having to have excuse me, 50 different licenses that they pay the fees for every year, and then they have to look and make sure that they're compliant. So there is a good cause for uniformity in terms of developing a good business environment. So overall, these concepts are good, and I understand justification that's provided. I will have an amendment in the one location where we provide the exemption, but otherwise I'm in support of the legislation.
Representative Greer.
Thank you, Mr. Chairman. And I think we'll want an amendment on section 3 to make sure that language is right. But I want to talk to the fee issue. You know, the justification of changing this is that, well, that's what we do with the other programs administered by the commission. And I do have a bit of difficulty with the legislature delegating this away. However, I also recognize, and this is a fluid area right now, of the ability for flexibility. And so I think, Mr. Chairman, I'm going to leave this alone, but I may look at something that's a little bit more global on my own by the time we get to session, that just puts some parameters and maybe some overall reporting above and beyond what I saw when I was on appropriations. So I just, as a legislature, we have to be careful for what I would call is an unlawful delegation to agencies. We just need to be careful. So that's the only comment I'll make on that.
Other comments, questions? Hearing none, sensing you're ready to work the bill. Does anybody have any changes to page 1? Page 2? Page 3, I think I heard somebody say they were contemplating something there. Nope. Page 4. Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, on page 4, line 14, restore original language.
Moved. Is there a second? Seconded by Coe. Discussion? You would like to talk about your amendment?
Mr. Chairman, unless anybody has any questions, I think you heard the discussion a moment ago, so I won't reiterate.
Mr.
Questions? Yes, Senator or Representative Greer.
Yeah, so Senator Rothfuss, this was, and we can do this right now, and I'll support your motion. But I just wonder if, in the purposes you had set out were exactly as I remember that. But I still think that we, and even though it's paper, should restate that. If we're making that a state law specific to that specific point in time in the federal code, we should take the time with an amendment, and I'd work with you in session to set that out. So it's one location.
Mr. Chairman, to respond to that, and I have absolutely no objection to that approach, which would basically be taking what's in the staff comment and codifying it there as subpoints to the Romanet 8. That sounds fine. It gets to the same objective without having to reference the Federal Register, which is a great solution. So I'd support that.
Other discussion on the amendment? Other discussion on the amendment? Hearing none, sensing you're ready to vote on the amendment. All in favor, raise your hand. All opposed, same sign. That was unanimous. All right, we'll leave that language in then. Anything else on page 4? Anything on page 5? Anything on page 6? Page 7? Page 8? Page 9? Page 10? Page 11? Okay, we've got that language fixed like we want. And yes, Senator Rothfuss.
Thanks, Mr. Chairman. I don't believe, unless I missed it earlier, that we have yet done the amendment on page 11 in section 3 to insert language that would require that it also apply to renewals. So I will make that motion that we incorporate renewals into the section 3 language as well.
Okay, page 11, section 3 language. Seconded by O'Hearn. You really like that one. I don't know that we need to discuss this one all either. We heard the discussion from Fuller. Are you all right, Senator Rothfuss?
Go ahead. I think everyone
Okay.
understands.
Any other discussion on this amendment? We're amending section 3 to add renewals into it. However, LSO needs to do that. If all in favor, signify by saying, raising your hand. All opposed, same sign. Motion carry, the amendment carries. Any others? Any others? Now we're ready to vote on this, but we're going to do a roll call vote. Yeah, that's what we're going to do on this one.
Good choice. Good choice
Yeah.
this time, Mr. Chairman. Thanks.
Yeah. So, Mary Beth, you're
Mr.
on.
Chairman, this is a roll call vote on 21 LSO 0002 version 4 as amended. Senator Biteman,
Aye.
Senator Coe,
Aye.
Senator Rothfuss,
Aye.
Senator Wasberger,
Aye.
Representative Burkhardt,
Aye.
Representative Crank,
Aye.
Representative Duncan,
Aye.
Representative Ayer.
Aye.
Representative Ayer. Representative Furphy,
Aye.
Representative Henderson,
He's excused.
Excused.
Representative McGuire,
Aye.
Representative O'Hearn,
Aye.
Co-Chairman Greer,
Aye.
Co-Chairman Anderson.
Aye.
That passes, Mr. Chairman.
That brings us to 11:30 and UW School of Energy Resources does anybody need a break? We could break for about 10 minutes here, still be ahead of schedule. Let's take a break till 11:15 and we'll start with the School of Energy Resources then. Thank you.
Senator Coe, what are you gonna do with all your free time now?
Well, I'm looking off my balcony, looking at the deck on the golf course. That's what I'm gonna do a little more of.
Well, so there's a whole group of women from around the state, including my wife, that golfed yesterday and today. So if you see her out there, you know, give
Oh,
her
she up here, so she's up here at Olive Glen?
yeah, yeah.
Okay. Well, it's a pretty day today. It started out dreary, but it's beautiful now.
Yeah, she was on Tuesday. She did a practice round, and it texted me that she was holed up, I think, on hole 5, or I can't remember which hole it was now, with the lightning shut down. You guys must have had a little storm go through on Tuesday.
Yesterday?
I thought it was Tuesday. What's today? Today's Thursday, right?
Yeah, we had some lightning in the afternoon the last couple of days, but
Yeah,
not today.
good.
It even tried to rain a couple of times, but never really got it done.
We are still live.
He
It
was
is
sitting on hole 5 in a lightning storm. Yeah, and it was Tuesday.
Okay.
11:15, and we're going to resume with the School of Energy Resources. I will turn the mic over to Dr. Kritka.
Thank you. Good morning, Mr. Chairman, members of the committee. I'm grateful to speak with you today. I'm just going to try and let's see, share my screen here. Oh, no. Mary Beth, can I share my slides?
Chairman, Dr. Crook, if you could try again, I think I've got that fixed.
Okay. Mr. Chairman, can you see my slides?
Yes, yes, very good. Yep.
Okay, great. So good morning, Mr. Chairman, members of the committee. I'm grateful for the opportunity to speak with you today. If you don't mind, since this is my first time speaking to this group, I'll just give you a short introduction on my background and to who I am. So since March 8th, I have been serving as the executive director of the University of Wyoming School of Energy Resources. Going back through my career, I've had a quite a varied a number of roles. My first job after my PhD was, and by the way, I'm a chemical engineer by training. I got my undergrad and my PhD at the University of Oklahoma. As far as my first job, I started in a very technical role, leading a team of researchers developing a novel carbon capture process, and that was down in the suburbs of Denver. Realizing the importance of communications, from there I moved on to work for a Chinese company, Shenhua Group, which is now called China Energy. And for them, I was the executive editor of a journal. It was called Cornerstone, the official journal of the world coal industry, and it was published on behalf of the World Coal Association. From there, I worked in the research department of Tri-State Generation and Transmission, and was exposed to the vitally important role of rural cooperatives. And then most recently, I was vice president of coal generation emissions technologies at Peabody. In that role, I focused on coal-related technology development, as well as the communications and government relations that go along with that. If there's a single thread that I'd use to tie my career together, I'd say it's a passion for the energy technologies, and particularly for fossil energy technologies, especially around carbon capture, use, and storage. And given Wyoming is a leader in this field, I've interacted with Wyoming stakeholders for years, and I'm so happy I finally had the opportunity to move here and work with individuals I've known for quite a long time. I also have a 9-year-old son and identical 3-year-old daughters, and a husband who's willing to follow me all over the place for my job. But I want you to know there's nowhere else we'd rather be than Wyoming. And so moving on to my presentation, I know I sent more slides out than we can actually go through, so I'm going to move through some of them pretty quickly, just knowing that they're there for your background, because we couldn't, even in 30 minutes, we couldn't talk about all the great stuff happening at SCR. So I'll skip through our topics since you have that. Going to SCR's mission, our mission is energy-driven economic development for the state of Wyoming. That means making sure that we're training students that can work in today and tomorrow's workforce in the energy industry. It means conducting outreach across the state to communities, companies, and others impacted by changes in the energy sector, and also finding opportunities. It also means doing applied research that will help solve Wyoming's challenges. And SCR, we don't do basic research. Our research program is very applied, it's not theoretical, and it's aimed at getting to commercialization as fast as possible. I want to assure you that my team and I are laser focused on driving revenue for the state of Wyoming, and that focus is the filter through which we view opportunities. We also understand that the Wyoming legislature must make difficult decisions about where to spend its funds, and that those decisions are going to be more difficult. I want to thank you for investing in SCR historically, and today I'm going to highlight technologies that would not exist without that investment, and also that are driving toward commercial deployment. I'd also like to highlight some programs focused on state priorities like carbon capture, use, and storage that are principally funded without state dollars. So moving on to just to give a little background on our appropriations. So this slide, I'm on slide 4, shows SCR's appropriations for FY21 and 22. And again, let me say we're very grateful for that support. As far as our budget, it's important to understand that our standard budget that's just under 19 million for the biennium underscores the salaries of key energy-focused faculty on campus. It supports our academic program and also our research portfolio. I'd point out that the second line, the 1.3 million in funding that's for an academic director, a policy center, and the centers of excellence is one time only, but those expenses are ongoing. So we're working to drive down costs, but we feel this can't be totally defunded. The third line on our budget is $7 million associated and focused on our carbon engineering program, which is aimed at supporting the development of a new process and products from Wyoming coal, and also focus on demonstrating the viability of those products. So note that any spending from that tranche of appropriations requires approval from the SCR's board, the Energy Resources Council. And the final line of appropriated funds is cost share match for Department of Energy large-scale pilot project focused on a new type of power plant called flameless pressurized oxy-combustion, and I'll talk about that in a little bit more detail later. So I'll quickly move through this slide, but I want to point out that SCR has historically and continues to support energy-focused work across the university. So we're very interdisciplinary. We don't house our own faculty here at SCR. They are distributed around the university in different departments, and that goes to the very nature of our interdisciplinary program. And even that, the number of departments and units around campus that we're supporting has actually grown in recent years. So let me just move quickly, just talk about a little bit about academics. So regarding SCR's academic program, we find that our students have excellent job placement in the energy sector and beyond. But I've launched a strategic review to understand how we can change the trajectory. We've had decreasing enrollment. In addition, there's a lot more interest in energy on campus when you poll students than the number of students enrolled in our program. So we're really interested in how we can impact the student body more broadly than we are from an academic perspective. So now I'm going to move to our research program. And on slide 9, I just wanted to show some very specific highlights of that program. And so on the call to meet with me today is Scott Quillinan. He leads our Center for Economic Geology research. This is truly a gem in SCR and the university's CAP, that program. So I'll talk about some of the things they've done. But first, let me talk about the structure of our program, our research program. So it's made up of 3 pillars. So the first is the Center for Economic Geology Research. The second is our Carbon Engineering and Emerging Technologies program. And the third is our relatively newly launched Center for Energy Regulation and Policy Analysis. So let me just hit on a few positive impacts at both the university and the state from the first two pillars that I mentioned, that since they've been around longer. So the Center for Economic Geology Research does use seed funding from our state appropriations, but it is largely supported with non-state resources. I'm incredibly proud to be associated with this team in any way. They have an international reputation in the space of subsurface carbon management and beyond. So I'll just point out a couple of benefits from the last 5 years for that group. When state funds are used for cost share for their principally non-state funded projects, that group has leveraged a 14-to-1 non-state to state support. In addition, this research is occurring in Wyoming. Over the last 5 years, the applied research being done by this group has resulted in $5 million being spent with Wyoming contractors, with another $6 million slated to be spent in the near future. And in fact, much of this team was in Campbell County this week, working with local contractors to do seismic testing for their Carbon Safe project that I'll talk about later. Moving on to our carbon engineering program. This is an area focused entirely on driving incremental demand of Wyoming coal. So coal beneficiation technologies, for example, are being developed that will make Wyoming coal more competitive, both in the US and international marketplace. We're also looking at new types of power plants, as I mentioned, the flameless pressurized oxy fuel or oxy-combustion FPO plant. And the goal with that plant is to develop a new type of power plant that can be flexible and cost competitive in a carbon constrained world. And again, we're grateful for the $12 million appropriated by the state for cost share, and we're working to use that to leverage $60 million in federal funds to develop that technology. In addition, in this program, our new uses for Wyoming coal, we have 8 patents that have recently been filed in that area, and those are really important, being able to protect that intellectual property, because while the School of Energy Resources, we do not commercialize technologies, but we have to work with industry partners who would be able to take these technologies to market, and they need to know that that's protected and that they can make a profit over the long term, because it won't be poached on, because the intellectual property is protected. So then that third pillar is the Center for Energy Regulation and Policy Analysis, newly launched last year. And all I'll say about that is it is really important, because energy policy and technologies don't exist in a vacuum. Often new technologies need some sort of policy to back them up. In addition, that center leads our support of both elected and appointed officials around the state, and that's what we're doing in real time. Let me talk just a little bit about competitive carbon management. So speaking about the Wyoming Carbon Safe project, this is a flagship project, not just for SCR, for the state and for the region, really. This project, the Carbon Safe project, is largely funded by the Department of Energy, and it's being conducted adjacent to Basin Electric's Dry Fork power plant. This is, like I said, principally federally funded. Its goal is to develop a commercial CO2 storage site that can take at least 2 million tons of CO2 per year and store a total of at least 50 million tons of CO2. It's a major step. This program is a major step in helping demonstrate CCUS technologies in Wyoming. And earlier this year, we were notified that that our group, the KEGR group, was awarded phase 3, moving into phase 3 of that project. So that'll start in October, and will take about 3 years. So we are continuing that work. One of the things that's really critical in the Carbon Safe project is that we're working with stakeholders in and around the state and beyond. And we have a wonderful project team for the Carbon Safe project. It includes stakeholders from Wyoming and beyond, including university, government units, nonprofits, and corporate participants. So now I want to speak also about another flagship project that we have, and that's our FPO project. I've mentioned it a couple times. So this project is focused on developing a new combustion technology that burns fuel in an oxygen-rich environment. So that results in a power plant that creates near pipeline-ready CO2. And so it's highly efficient. It doesn't need downstream carbon capture, and it's flexible and would fit into a carbon constrained world. So while our current project, which is DOE funded, that principally DOE funded, is focused on coal, I do want you to know this technology could work with Wyoming natural gas, coal, biomass, and waste. And today I have an announcement related to this project. So this slide, I'm on slide 14, that I submitted to this committee only a short time ago, is actually already out of date. We are now adding Black Hills Energy to our project team, which is very recent development. Currently, the project is in phase 2. If we're selected by the Department of Energy to go to phase 3, which includes design, construction, and operation of this pilot scale combustion facility, Black Hills Energy has agreed to host the pilot scale demonstration near its Gillette Energy Complex, or at its Gillette Energy Complex near Gillette and in Campbell County. So while the original concept was to demonstrate this technology in Laramie, the change is fully endorsed by the project team for a number of reasons. Partnering with a large utility will ultimately make us more successful, both on developing the technology on the technical side, as well as pursuing the phase 3 of this project. Again, that's a competitive down select. So we have to be selected by the Department of Energy to move on to phase 3. And having a large utility on board absolutely will help with our application. We will also realize substantial cost savings to that project by being next to an operating power plant and mine. And there's so much more that as we've began to peel the onion in our discussions with Black Hills, all the ways that being involved with them and working with a leader in this space like Black Hills is going to help that project, including experienced operators and a utility that has experience with oxy-combustion. So our new host site has many attractive traits that are going to benefit the phase 3 of this project. And importantly, the proximity to the Gillette Energy Complex will facilitate research collaboration while remaining separate so as not to interfere with commercial operations. So it's the best of both worlds. And Black Hills Energy is committed and partnering with us to provide construction, operational, and maintenance support. So we're incredibly grateful to Black Hills for being willing to engage with UW and our project partners on finding solutions for Wyoming. While there's many challenges ahead, having industry engagement like this going forward is going to help us meet those challenges and help us be more successful than we could on our own. And again, I'd point out none of this would be possible without the cost share appropriated by the Wyoming legislature. So moving on to our carbon engineering initiative. Let's see, as I said, our initiative is focused on technologies that will enable the incremental production of Wyoming coal. And I'm going to move quickly through some of these. So the first slide, slide 16 in this section, is for your reference, and it's focused on beneficiation technology. The one thing I wanted to point out on this slide was the 2 photos on the left-hand side. These show just a matter of weeks ago, the rotating kiln being placed at this pilot plant, which is a piece of technology that is the development's being supported by UW Research. And so this change in the process and the overall beneficiation process was really novel. And we think it's important piece of equipment that's going to help get this technology to market as soon as possible. And again, this technology is focused on making Wyoming coal more competitive at both the domestic and international locations. And of course, we can't forget about all the other potential products that we could create from Wyoming coal. So SCR is in the process of developing a thermochemical process that creates new products from Wyoming coal. We have small scale facilities operating on the University of Wyoming campus currently, and we aim to demonstrate this in the field by 2023 in an integrated process. You can see from this slide, there's lots of different potential products that could be created from this thermochemical process. And we not only have to demonstrate the process, but also the viability and in many cases, superiority of those products. So this slide I'm on 19 is a list of products we've identified from the thermochemical process. I'm sure there will be more products than what are shown here. What I'd like to point out on this really is that SCR is focused on scale. We want to make sure that that we're using a lot of coal, and that's what's going to drive the revenue associated with this. So we're targeting products that can have the largest applications. So that includes soil amendments, asphalt and paving materials, and building materials. So those are our targeted products. They're big markets. But the process, because we target those specific things, it also has a lot of byproducts. So our research program also is focused on what to do with all those byproducts. And so that's kind of the overall focus. And again, we're working to demonstrate this integrated process in the field in 2023. So while the pandemic has slowed us down a little bit, we are absolutely still driving toward that goal. So I won't go through slide 20, except to say that this is for your reference, that I wanted to provide an update of some very specific examples of our carbon engineering program and how we're working with industry partners. So moving next to a different topic, critical minerals and rare earths. We also have a program in this space, again, led by Scott's area, the Center for Economic Geology Research. And this is a growing area of interest in a potential growing industry that has major national security implications. I'd add this area does not exist in a vacuum, and there's downstream industries such as rare earth element and critical mineral extraction, concentrating and manufacturing that would need to be considered and could also offer benefits to the state. So, and I'll also say some of the knowledge we're building as we study and we do research in this area could definitely be used to understand other Wyoming mineral wealth better and how to access that. So this slide, slide 22, is a slide we regularly show when we talk about the fact that Wyoming has both conventional, like the Bear Lodge complex, and unconventional, for example, coal and coal byproducts, oil and gas produced water, and the Phosphoria Formation. Those are all unconventional sources of rare earth elements. And SCR has been working on rare earth elements for years, and we have recently been awarded a collaboration that's $1.62 million with the National Energy Technology Lab, as well as Campbell County, the City of Gillette, and Energy Capital Economic Development. And that's focused on rare earth element characterization and extraction from coal fly ash. So you can see on the bottom half of this slide, we have a wide array of near-term future opportunities. And rather than go through these, I just want to point out a couple benefits. Number one is that as we do research on this, we are training students to could help create an industry in Wyoming. And we're also developing technologies, just look at these two, like drone sensing of rare earth element and critical minerals, and machine learning techniques using Pathfinder elements. Those are technologies that could be used outside of rare earths and critical minerals. Just think about something like if vanadium batteries took off, we could use this to try to more quickly identify Wyoming's vanadium resources. So I want you to know that even this work focused on rare earth elements could be much more broadly impact the state of Wyoming. And I'll skip this slide except to say it's something we've been showing a lot to federal stakeholders. What I always say is those red lines represent samples of rare earth elements in coal that are higher than 1,000 parts per million. And out east, they have quite a very dense group of red lines where we don't. And the reason is because there's been so much less characterization in Wyoming and out west. So we message a lot that more work needs to be done, and we're working on getting more grants to do that from the federal government. So next, I just have a little bit on SCR's Center for Energy Regulation and Policy Analysis. So it's a relatively new center led by Kip Coddington, and on policy, we just have provided some examples of projects that we expect to complete over the next year, in addition to real-time support of Wyoming elected and appointed officials that we're already doing. And then I have a few slides, mostly for your reference, on the Center of Innovation for Flow Through Porous Media. I won't go through these. I'm not the best person to talk about this research program, but I do want you to know that the High Bay facility shown in, let's see the next slide here, was inaugurated in 2017, and the state of this research program is very strong. We also have strong corporate sponsors, and there's a slide here that for your background that tells you the type of research they're focused on there. So that's all I had as far as my prepared remarks. I just, again, want to thank you for your time, and I conclude by saying that at SCR, we understand our mission. And we aim to deliver to the state of Wyoming in meaningful ways that yield a workforce of tomorrow and technologies and policies that will drive revenue for the state. So, thank you.
Thank you, Holly. I guess I should have introduced this better. The reason you're hearing from the School of Energy Research is because the legislature funded them 13 years ago. The university was going to back off of engineering, and the legislature felt strongly enough about it that they'd fund the School of Energy Research themselves. So they put up $20 million, and we've been funding that way for the last 13 years. There's a board called the Energy Research Committee that governs the School of Energy Resources, and that's made up of industry and legislative people. There's 9 of us on there, I believe. So that's why you're hearing from them, and it's for the newer members, so you know what we're financing at the University of Wyoming. And it's blossomed into actually financing people in other departments, engineering, law, lots of different areas. So it's a very important part of our students getting a graduate degree and contributing to the minerals industry in Wyoming. So Representative Greer, you had a question.
Yeah, thank you, Mr. Chairman. And Dr. Krupka, I tried to interrupt you, but you were on a mission, and a good mission at that. But hey, and this goes to Senator Anderson's point, and I want to go clear back to slide 5. And I think this is a little known component of it, but as Senator Anderson said, the legislature 13 years ago, when they had this vision and had it stood up about 10 years ago, was how do we drive centers of excellence, and how do we do that around natural resources? And the School of Energy Resources is that vehicle. And I don't know, Dr. Krupka, if you know the statistics on this, but there's one great example of this that occurred, and it was with the business the business college of business. It was business or commerce and industry when I went to it. But we had an MBA program, but it was lackluster, to say the least. And the School of Energy Resources committed, and I'm going to be off on these dollars, but about $500,000 a year, and push that into that to enhance that MBA program. And a lot of people get their MBA online. They're working professionals. And as a result of that, and I don't know the number of years, but it was like 3 or 4 years, you saw our rating as an online MBA program at the University of Wyoming go from the cellar to one of the best in the country. Not the Harvard, but some of the best in the country. And once that got stood up, the funding could be pulled back and then moved to another place. And I don't know, Holly, if you know that whole story and can tell it better than I, but it is a component of the School of Energy Resources that is often overlooked.
Holly, would you like to address that?
Yeah, thank you, Mr. Chairman. And Mr. Co-Chairman, first of all, I'm sorry I didn't see you. You're right. When I get ahead of steam, I just go for it. But yeah, so I do not have the statistics. I'd be happy to get that to you on that particular program. But I would say one of the things that you've highlighted one story, but I think there's a number of opportunities or stories like that, because we have a bit of flexibility with the funds appropriated to us that we can help, and we can be nimble and flexible and help stand up both research and academic programs in a relatively quick manner. And so yes, that online MBA program is a great example, and I think there's others as well. So yeah, I think you've highlighted a key point. That's just us being allowed to, or us being able to be nimble and jump when something is really needed across the university.
Okay, thank you.
Scott, are you going to add, are you going to tell us about that well you drilled in Gillette or in Campbell County? What you're doing with it? How important it is to our industries?
Mr. Chairman, I would be delighted to. In April of 2019, we drilled a stratigraphic test well proximal to Dry Fork Station. It was a 10,000-foot well. We were able to take core and fluid and geophysical well logs from the strat test well. That allowed us to investigate the subsurface directly below Wyoming's newest coal-fired power plant for feasibility one day of being able to put CO2 underground there. Over the last year and a half, we've been working with that rock and putting it into models, and we feel pretty confident that we could put CO2 down there safely and economically. As Dr. Krutke alluded to earlier this spring, we were awarded phase 3. It'll be a $19.5 million project where we'll go out and we'll drill a second well. We'll reopen the first well that we drilled in 2019. Both of these wells will be re-permitted under Class 6. Hopefully soon, Wyoming will have Class 6 primacy, so we'll be working closely with the Wyoming DEQ to permit the first 2 Class 6 wells in Wyoming. Along that second well will allow us to do the injection testing that we need to dial in the last bit of our models so that we can put our stamp on this and say, yeah, this is a great place to put CO2 in the subsurface, and it'll be a great place to commercialize the technology. Along with that work, we're also doing the techno-economics and the policy work that needs to be done to stand up a commercial industry like this. So Senator Anderson, thank you for the question. It's a great project and it's moving towards commercialization.
Scott, would you go through the Class 6 well? I think that's pretty significant that Wyoming is going to be writing some of the rules on that and whatnot.
Mr. Chairman, absolutely. All CO2 injection wells are regulated through the EPA, through the Class 6 well program, unless you are doing enhanced oil recovery. Those are regulated through a Class 2 well program that the state does have primacy for. But to move forward into saline geologic storage of CO2, you need a Class 6 well. Currently, that's regulated under the EPA. The Wyoming DEQ has submitted their application. It has been recommended for approval. It has not been finalized, but I expect sometime between now and November, we'll receive an announcement that Wyoming DEQ will have primacy over Class 6 wells. Why is this important? It's not that we're at ends with EPA. They do a great job, but it just allows us to access the local knowledge, the local geologic knowledge that's inside Wyoming Department of Environmental Quality, and it should help us move these Class 6 wells applications through the process much quicker.
Good, thank you. Thank you. Any other questions for Dr. Krutke and Scott? No?
Mr. Chairman?
Yes.
And I actually have more of a question for the committee on, SER is doing some exciting stuff, and they are, in essence, the tip of the spear for us to go from theory to something that is practical and usable, scalable, I think is probably the right term, to move us forward. And I'd just like the committee to, think about questions or any projects that they would like to have a more detailed presentation on, because Senator Anderson and I have sat through many. We've heard them, and some of them are quite fascinating, really. So if you've got anything that you would like to hear more on, let Chairman Anderson and I know, and then we can get Dr. Krutke up to present in some time in our November meeting.
We've got a little extra time, Dr. Krutke. Representative Burkhart.
Thank you, Mr. Chairman. Just a quick question to the co-chairman's comments is, how much time will we have in November?
What is November, 30 days, 31 days? As much time as you want, Representative Burkhart.
Okay. I have plenty.
We've got a little time, Holly. Could you expand on the high bay research that we're doing? That we kind of breezed over that, but that's huge in the state, in the nation, and in the world. The research they're doing there on porous rock.
Mhm. Yes, so the High Bay, thank you, Mr. Chairman, also. So the High Bay Research Facility houses the Center of Innovation for Flow-Through Porous Media. And so that facility has been developed with over $100 million of investment from both the state and then the private sector and corporate sponsors. The center provides imaging capabilities at the atomic, nano, micro, and macro scales. And it establishes an unparalleled capacity for scientists can conduct numerous studies in parallel, and they also have modeling components to that. I'd say it's a world-class facility and a world-class research program, to be clear, with a distinguished track record of scholarly publications in technology development. The goal is to spin out that technology for commercialization, and so they also have a commercial arm operating out of that High Bay facility. And the technologies being developed there principally have been focused on oil and gas recovery. However, that is not the limit of that. There's also CO2 sequestration and other areas of science and engineering. I have heard that there's applications in rare earth in the health industry and much more. I believe they even did some scanning of an insect recently. So they have world-class capabilities and a broad potential research portfolio, but they are busy night and day, focused on their core areas of oil and gas production. So it's, let's see, what else can I say about it? I have a list on slide 30 of the slides I provided. They have examples of the technologies that have been developed there for both unconventional reservoirs and conventional reservoirs. So for example, unconventional is examples of the technologies include foam-assisted hydrocarbon gas injection, confined fluid phase behavior, advanced well simulation chemicals, multi-phase flow in propped and unpropped fractures, proppant wettability and fracture conductivity. So that's just examples of what can be done for unconventional reservoirs. But I think one of the most powerful things that when you go over there, you'll see is the differences in the scales that they can evaluate there. So they'll have samples that actually have to be lifted up through the floor because and tested in large scale machines, but then they also have something that's smaller than the point of a pen or pencil. So they're able to understand the flow through porous media, both at the pore scale and then as you get larger and larger, and then they have all the computational ability to back that up. So on conventional reservoirs examples, they've developed digital rock technology and they've looked at enhanced oil recovery. They are working with the Enhanced Oil Recovery Institute on a DOE funded project, and they've looked at nanofluids. So wide array of work going on over there.
Wonderful, thank you. Any other questions of Dr. Kretka and Scott? Hearing none. Thank you, Dr. Kretka. Thanks SER for what they're doing for Wyoming Industries. Thank you.
Thank you, Mr. Chairman.
Any other public comments? Any other public comments? I don't believe there's anybody in the waiting room. Mary Beth, I don't think we have anybody public comment.
No, Mr. Chairman, you do not.
Okay. All right. Wonderful. Next order of business is lunch. It's supposed to be from 12 to 1. Is that what the length you want to go, Representative Greer?
Yeah, Mr. Chairman, we better, in one, great job keeping us on the task here. You manage an agenda better than anybody I know. But yeah, we better come back at 1 for the air ambulance because we have received a lot of comments and we do have quite a few people so we better do that out of courtesy to them.
Okay, we'll adjourn till 1 p.m. Mountain Daylight Time. Have a great lunch. I'd buy you lunch.